Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack's at Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning. Happy Thursday. Happy Thursday, March 12th, 2026, my friends. And we're going to Lawrence, Massachusetts today for the final pretrial hearing in the Kelsey Fitzsimmons case. Massachusetts versus Kelsey Fitzsimmons. How's everybody doing today? So many things dropped yesterday after we went off the air. So many things dropped. And there's a lot of buzz out there. A lot of buzz. Be careful what you write in the chat, please. YouTube doesn't like it. If you know what I'm talking about, you know what I'm talking about. The clerk tells me there is no Zoom today. And remember when we used to cover hearings when she was in the Salem courthouse, the only thing they had was a party line where you had to call in on a telephone line. And I remember one day Tim Bradl was told that the hearing was going to be on over the phone or virtual. And so did a lot of supporters called in too. And we apparently overloaded the phone lines and the judge was very mad. And so the clerk's office told me there's no information. I know Law Girls were trying to go and stream for us. And I know that NBC 10 Boston usually puts it up very last minute. So we're just going to have to wait and see what we get. We're going to have to wait and see what we get. But in the meantime, thank you all who are being so cooperative with me. Suzanne, especially for helping me try to find an actual mainstream channel that's going to be filming so that we can get the good sound and camera that you deserve. Yeah, I heard Turtleboy is there. Let's there was a lot of chatter before the chat. And I just want to, here's the ground rules. Nobody in my chat should be trashing other creators. Okay. I don't allow it, even if they're not people that are my favorites. So just kind of like, don't do it. That would be nice. It's a Microdots hat. Yes, I'm representing Microdots. NBC 10 is confirmed. Thank you. Thank you very much. Did you hear that Julie Grant got fired from Court TV? Sadly, so did Matt Johnson and just about everybody else. Just about everybody else, except it's unclear whether Vinnie Politan got fired. And I watched his show last night because I happened to get Court TV on my television. Many people don't. And he didn't mention anything about leaving the network. But Suzanne, not Suzanne. Sorry, Suzanne, I was thinking of you. Julie Grant did give a very, tearful goodbye. And yes, they're done. Court TV's done. And I don't know. I mean, I don't know if anybody really cares. A lot of people just stopped watching Court TV. Yes, Law and Crime, which is Dan Abrams, bought Court TV. And they're changing their programming. I don't know what that means. They say maybe it's going to be more virtual. I don't know what that means. Does that mean YouTube? Does that mean, they're only going to stream trials and they're not going to have any reporters on the channel. That's unclear too. And so that will remain to be seen. Let's see. I'm just going to put the NBC, you said NBC 10, right? NBC 10 up on YouTube and see if they, and if it's good if it's on YouTube, because if we're a little bit late, we can rewind, we can pause. The problem is when it's on a website of one of these news channels, we can't pause, we can't rewind, we can't do anything like that. So we're going to see what we can find. But in the meantime, check out, and I was really surprised to see this last night on mainstream media, because they barely cover anything that we cover. Nobody still to this day that I'm aware of on mainstream media has covered the Lucy Medina verdict or trial at all, which is crazy because I know, we all know that that case never should have gone to trial. And also Hank Brennan was trying that case for the defense, which would make you think, being a Massachusetts, maybe mainstream media station, that you would cover it for that reason alone. But they didn't, because he didn't want any of you to know about it. So here's what happened. Here's the article from Boston 25 from last night. Let me show you this, because I couldn't believe they put this out there. Some new motions were filed too. The defense wants the employment records for Noonan. They want the employment records for Justin and any disciplinary records, including any drug use of Justin. And here's what came out last night. And I couldn't believe that this is Boston 25, ran this story, because here's a picture of some still shots from surveillance footage outside of Kelsey's home in the backyard. It's dated April 10th of 2025 at 11:37 a.m. And it appears to be Justin smoking something. Some family court papers, an affidavit in family court that was just released yesterday that Kelsey signed off on said that he was constantly smoking the reefer, and that these still shots and video show him smoking what appears to be a pipe reefer. So you can see, if you zoom in here, maybe it is, maybe it isn't. But this is so speculative that I was shocked that I saw Boston 25 covering this. Now, if you know or you don't know, at least here in New York, okay, weed is legal here if you're over 18. But FDNY is not allowed to smoke it. Doesn't matter if it's legal, doesn't matter if you have a medical card, it doesn't matter. If you are a firefighter here in New York, you are randomly drug tested and you're not allowed to smoke, okay? That's just it. That's just the rule. That's the rule. And if you get caught and you pee dirty, you're out, okay? So I don't know what he's smoking. And I don't know, listen, did Kelsey play it classy up until she had no other choice but to release this stuff? I don't know. But it seems like she did. And no matter how badly Justin was trashing her in the media, and that bogus interview that he did last Friday that we covered, where he wouldn't let them tape it or record it. But he didn't break into her house. He had every legal right to be, okay, you want to play? Now you're going to play. And I don't know what he's smoking. I'm not going to speculate about what he's smoking. The fact that, the fact that the mainstream media would publish this is kind of shocking to me, right? Because they won't even publish stuff when it's actually true and they can actually prove it. Like, John O'Keefe didn't get hit by a car and stuff such as like that. Okay, so here's the pictures. Here's one picture where it looks like he's smoking out a window, like you used to do. Maybe when you were in high school smoking cigarettes, you'd open the window in your bedroom and blow the smoke out the window. I never did that. And there he is behind the shed, or what looks like the shed, trying to keep it quiet or keep it clandestine, but it's not exactly working for him right there. And so I was kind of shocked. Were you shocked that they published this without any actual proof? Could this be considered, defamation? I don't know. The videos are clear, but you don't know what he's smoking. It could be anything. Could be crack, could be meth, could be pot, could be tobacco, could be anything. Could be like hookah. stuff. I don't know what they smoke in hookahs because I don't do that, but I just don't know. All right. But I thought it was interesting. And so here's the story. And then there's some video as well. And remember, Kelsey's dad is a security expert. He has a security company. I saw all the papers. I have all the papers. We can't do them right now because we're going to try and cover the hearing first, and then we can cover the papers after. So that's Kelsey's backyard. And this is in April. This is right. Remember, the baby was born in February. And apparently there's a lot of video attached to the court papers. So there's that. Let's take a look at the article that they published alongside this. And this was from last night. Defense seeks records on fiance's alleged drug use in Kelsey Fitzsimmons case. North Andover, Mass. The defense team of Kelsey Fitzsimmons is asking the North Andover Fire Department to turn over disciplinary records related to her former fiance's alleged drug use. Kelsey Fitzsimmons, a former North Andover police officer, was shot inside her home last summer while officers were attempting to serve a restraining order. Well, they served it all right. Fitzsimmons is accused of pointing a gun at officers when they arrived at her home. Her attorneys argue she was a new mother struggling with postpartum depression at the time. Well, we know she was. We know she was because she was served with the order. We saw them come in the house with the order, and then she was shot. Back in February, Fitzsimmons' lawyers alleged that her fiancé, Justin Aylaian, along with several other men, broke into her home 3 days after the shooting on July 3rd of 2025. The incident was captured on surveillance video. We watched that surveillance video too. Authorities said they would not be pursuing criminal charges against Aylaian. Right, because they need him to testify in their case. Such a conflict. We've been over this a million times, but we'll probably go over it again today. Maybe it'll be brought up again in court. Now, new videos shared with Boston 25 show Aylaian smoking what appears to be a marijuana pipe or bong behind the house and outside a window months before the shooting. Here's some still shots that they published, which are right out the window. And apparently there are hundreds of videos like it, according to the court papers. Most firefighters in the state of Massachusetts are not allowed to smoke on or off duty and are required to take drug tests. And that includes vaping and cigarettes, right? It's smoking is smoking. The defense team is claiming that by using the video of Aylaian smoking hundreds of times as evidence during her trial, his accusations against Fitzsimmons will be proven to be not credible and that they constitute relevant, powerfully exculpatory evidence. They further argue that this supports her right to a fair trial. There's a picture of Kelsey at an earlier hearing. Her defense attorneys are also requesting past documentation of misconduct involving Officer Patrick McCarthy Neyman from both the North Andover Police Department and the Lawrence Police Department. Noonan is the officer who shot Fitzsimmons. So those are two Rule 17 motions that are going to be heard today. One is for the records of Justin from the fire department. The other is from Noonan. For Noonan from not only North Andover PD, but also Lawrence PD, because he worked at Lawrence PD before he was transferred back to North Andover. We've been over that a couple of times. We saw a Facebook post where he was welcome back to North Andover. And based on the wording of that Rule 17 motion, it seems that maybe they're speculating that he left Lawrence PD under not so upstanding circumstances. I don't know that for sure, but that's the wording that makes me believe that, in my opinion. There's a scheduled hearing today regarding the videos to be allowed into the trial and the defense's motion for these documents. This is a developing story. It says, check back for breaking news alerts. So that's just part of what's going to be happening today. They're also going to be talking about Kelsey's bail conditions, which the judge agreed to amend some of them. And then yesterday we just saw a blurb on the docket where the judge said that he wasn't going to overturn the other conditions of her bail because they had already been decided by another judge. And it's his feeling that they need to go back to the same judge, Judge McCarthy Neyman, who heard the dangerous hearing initially. Remember, we also looked at another case yesterday involving a child predator who also had a dangerous hearing. And I think that was in another county. If you guys remember, let me know. And he was let out. Allegedly, he raped a girl between, there's so many of these cases I can't, between the ages of 5 and 11, several times a month. And he was let out by a judge, another female judge in Massachusetts, on something like $5,000 bail, cash. So stay safe out there in Massachusetts, because it's insane. And you know what's insane to me is that most of these judges that are making these insane rulings are female. Sue's chiming in. Justin also has firearms and a firearm permit. If you're addicted to drugs, you can't have a firearm permit or possess firearms. Justin may be in deep trouble. This whole thing is getting really... what's the word? What's the word that I'm looking for? Because I remember when I first started covering this case all the way back in July, I said, there's more to this story. There is so much more to this story than we know. And now it's all coming out in dribs and drabs, but it's still all coming out just the same, just as we knew that it would. Let me pull up for you, because I know you like receipts. The family court papers that came out yesterday that Kelsey filed. It's an affidavit that Kelsey swore to under oath. And let's take a look at these. If I can get them in some sort of order. Oh, that other case I was talking about was Alex Castellano, who, this is in, he's charged with statutory rape of a child. And he was arraigned on February 20th, held over for a dangerousness hearing until the 23rd. And then on the 26th, I think that's when he was let out on something like $5,000 bail. And that was another female judge. I can't, the docket number that I have here doesn't tell me the county. And so I don't want to misname the county. The hearing is scheduled for 10. So let's just, we will get there. Hopefully someone's going to be streaming it and we can do it. It's 9:48 right now, in case you're wondering what time it is. Okay, let's take a look at these papers, because there's a lot of allegations in them and a lot of tea. And these were published yesterday. Let me see if they have the exact date of filing on them. They were filed yesterday as well, March 11th, 2026, in the Essex Probate and Family Court. It's kind of weird to me that both of these courts are together. In New York, we have family court, which is where child custody disputes are handled and things such as like that. And then we have a probate court. Probate court is for wills and estates and the probate of, oh, they just put up their YouTube. You guys are on it. You got it. Who's better than you? Who's better than you? I mean, I don't need a personal assistant, because right now I have 4,314 people in the chat that are willing to be my personal assistant. You know, it's just me. It's just me screaming into a microphone about this case, particularly since July 11th, I think it was, 2025, which was 11 days after Kelsey was shot by Officer Patrick Noonan. And the more stuff that comes out, the more we realize why they're going after Kelsey, because you know. All right, let's go. I don't know why anybody would go into Baker's stream and ask him to send me anything. That's yeah, you shouldn't do that. Don't do that, you guys. I got it under control here. Let him have his channel. That's just, you know what that does? When you go into another YouTuber's channel and you mention or promote another YouTuber's channel, it draws the audience away from that channel potentially and onto someone else's channel. And it's just not a nice thing to do. Okay. I started covering this right 11 days after her shooting. All right, let's go here. This is the trial court, Waltham District Court Division, Justin Aylaian versus Kelsey Fitzsimmons. This is in the family court, and this is an affidavit of Kelsey Fitzsimmons in support of a motion for further temporary orders. Remember, they had agreed on temporary orders, and they had stipulated to the custody issues and other things, such as I suggested. Hang on one second. And this is an affidavit. This is sworn to. Kelsey Fitzsimmons hereby deposes and states under oath. 1, I am the defendant in the above captioned matter and the mother of Caden Aylaian, hereinafter child or son or Caden. Plaintiff Justin Aylaian. Justin is the father of the child. Justin and I lived together at 125 Phillipsbrook Road, North Andover, Mass. between March 2024 and June 27th of 2025. She's saying that he moved out 6 days before he broke into the house. I owned that home solely and individually. I sold my home located at 125 Phillipsbrook Road, North Andover, Mass. on November 7th of 2025. Right, she had to sell her home for attorney's fees. 5, I've been our son's primary caregiver from his birth until June 30th of 2025, when Justin served a 209A order on me in my own home. Well, he didn't serve it personally, but 3 of her fellow North Andover police officers did, 3 male ones. I took maternity leave to care for our son immediately after his birth, made the appointment for his pediatric visits, attended the same, grocery shop for him and our family, woke with our son during the night, breastfed him, clothed him, and ensured his safety. Not a single provider has had concerns about my attention or caregiving or safety of my son with me. And when she says provider, she means medical providers. On December 23rd, 2025, I was released on bail from Western Massachusetts Regional Women's Correctional Center, pending a criminal trial on a charge of 1 count of assault. Yes, I know. The hearing is starting at 10. I have it up on the other screen. Let me get through these papers first, okay? Don't worry, we're not going to miss a thing. Promise you. Promise you, I wouldn't do that to you. Remember, so she was airlifted on June 30th. She was in the hospital for 53 days. She had 5 surgeries after being shot point blank in the chest by Officer Noonan. And then from there, she was transferred to Chicopee Women's Prison, which is 2 hours away from the courthouse, because number 1, she's a police officer, and number 2, before that, she was a corrections officer. So for her safety, in air quotes, they moved her to Chicopee. So she hasn't seen her baby since June 30th. And she essentially was locked up, not just in the hospital, but then after that in Chicopee while the appeals process worked its way through for 6 months. A breastfeeding mom. Yep. 5 surgeries. Yep. Eight, I do not believe it's in Caden's best interest for Justin to have sole custody due to Justin's use and abuse of drugs and alcohol, and because I am a loving, competent mother who should be involved with the decisions of our son jointly. She's telling us everything. 9, I have witnessed Justin obtaining and snorting Adderall. I didn't even know you could do that. In one such instance on Christmas Eve 2024 at Justin's parents' house, when I was pregnant with Caden, Justin obtained Adderall from his cousin Michael. Oh, she's really telling us everything. I saw Justin snort the Adderall through a straw in a bathroom that connects to a kitchen where I was standing. Justin admitted to me that he obtains approximately 10 Adderall pills from his cousin Michael every time he sees him, which is approximately 5 times per year. 11, I am prescribed Ativan to treat my anxiety. On at least 15 occasions, Justin would take one of my prescription Ativan pills when he was hungover, as he believed it alleviated the symptoms of his hangover. I witnessed Justin taking acid in the summer of 2024. Unbeknownst to me, Justin kept a tab of acid wrapped in tinfoil in our refrigerator for months. On that occasion in 2024, when Justin was not working, I witnessed Justin remove the tinfoil package from the fridge and put it into his mouth. Justin informed me that it was acid when I asked what he was doing. is blotter even still available? I mean, I was on Grateful Dead tour in the 90s and there used to be a lot of it, but I didn't even know you could still get it. Just keeping it in the fridge. It's just in the fridge. Summer 2024. Remember, the baby was born February 2025. I think so. She would have been pregnant, right? Justin informed me that it was acid when I asked what he was doing. I have witnessed Justin smoking marijuana, and I've recently come across video surveillance where he smoked marijuana at our home. I found over 100 such videos. Good comment, BB. I'm going to star that for later. Justin told me that he took hallucinogenic mushrooms with his brother Brendan in 2024. Oh boy, Brendan, Michael, she's telling us everything. She's name dropping all the names and swore to this under oath. Brendan has a civil position in the Air Force and he's randomly drug tested. As a result, Brandon does drugs with Justin at the beginning of his trips, usually the last 2 weeks, when Brendan knows the drugs will be out of his system before his next test. Justin told mother, meaning Justin told Kelsey, that he and Brendan microdosed after a getaway in the winter of 2024. Justin is a frequent customer of the Mellow Dispensary in Haverhill, Mass. Even though Justin is not permitted to use marijuana products in any form due to his job as a North Andover firefighter, Mellow, not to be confused with Ken Mellow, because this is spelled with a W at the end, like Mellow Yellow. Justin would often ask me for cash or take money from the ATM so that there was not a financial trail of him buying marijuana at the Mellow Yellow Dispensary in Haverhill. Shout out to the Mellow Yellow Dispensary. At times, Justin would purchase marijuana from Mellow Dispensary while mother and baby were waiting in the car. I mean, it's legal there, but not for firefighters. I think. I mean, I'm not sure of the regulations of the North Andover Fire Department, but I'm pretty sure. Justin would frequently smoke marijuana at our house, and there was a plethora of marijuana paraphernalia, including but not limited to a grinder, a blunt, and a pre-roll found in our basement. Dispensaries keep detailed records. Just saying, says Remy. Also, don't they have pretty strict security systems? Pretty strict cameras? And all sorts of surveillance in a dispensary. Anybody watch Tulsa King first season? All right, we're going to court. Nothing's happening right now. So let me finish reading because she's telling us everything. Justin would typically purchase rolls from Mellow Dispensary on Thursday because the dispensary has a Thursday only deal on pre-rolls. Justin would also purchase 1/8 of an ounce to grind up and use in a bowl. Everyone, shout out Thursdays. They have a Thursday only deal on pre-rolled if anybody wants to head to Haverhill. I also have serious concerns that Justin's an alcoholic. I've witnessed Justin drinking alcohol almost every night, drinking during our relationship with his beverage of choice being 1 or 2 Tall Boy Voodoo Ranger beers, which is 19 ounces with a 9.5 alcohol percentage, and 1 or 2 nips of Jack Daniels and or root beer flavored McGillicuddy. I didn't even know that was a thing, root beer flavored McGillicuddy. Gross. On other instances, Justin would drink a whole bottle of wine I would obtain at my mother's house after Sunday dinner, which we had weekly. During Christmas of 2024, both my father and my stepfather gifted Justin bottles of whiskey. Both bottles were gone in less than 2 weeks. And I recall this because my father came over during that time and asked Justin to share a glass of whiskey that he gifted Justin, but Justin informed my father that the whiskey was gone. That was around the same time that Justin's grandma allegedly wrote him a check for $5,000 in air quotes for the baby before the baby was even before the baby was even born. I have also witnessed Justin's hands shaking on numerous occasions. Justin has told me his hands also shake at work, which he attributes to alcohol withdrawal. That's a problem. DTs as a firefighter. Anyone? Bueller? As a result, Justin has told me that he often needs to drink the cooking wine at the firehouse in order to stop the shaking. We'll hear the dog. All right, here comes this. While I was pregnant with Caden, Justin would drink to excess at every family event or get together we attended, including at our joint bachelorette party event in Maine in June 2025. That's where allegedly all these incidents happened that forced Justin to go get the restraining order on June 30th. That was the Jack and Jill bachelorette party. At that event, Justin was intoxicated and kept drinking after I went upstairs to sleep. He refused to sleep to keep partying. We got into an argument stemming from Justin wanting to do more drugs. I left hours later to go home without him. Well, that's what happened at the bachelorette party. She's telling us everything. Justin's got a totally different story. And isn't that the reason, maybe, perhaps, why, in my opinion, he ran to court 2 days later to get a restraining order against Kelsey? We got into an argument stemming from Justin to wanting to do more drugs. That's what the big argument was about. Wait, I need sound effects for that. NBC 10 just cut their camera for a minute. I don't know. There might be more than one hearing, and maybe they had to turn it off because there's other hearings happening right now. We got into an argument stemming from Justin wanting to do more drugs. I left hours later to go home without him. Remember, he said he went to a hotel because he was so afraid of her that his friends would drive him to a hotel. On Mother's Day, 2025, I took a video of Justin screaming at me while he was drunk. During the course of that day, and as a result of his excessive drinking, Justin fell in the shower in the bedroom and while walking up the stairs. Signed under the pains and penalties of perjury, March 10th, 2026, XOXO, Kelsey Fitzsimmons. I always tell you there's always 3 sides to every story, right? This is the other side that we haven't heard until now. Are you surprised? All right, so NBC 10 is in the courtroom. However, they had to turn their camera off for a moment. I just want to go back to see. The court officer said something to them moments ago. This is in Lawrence today, right? Okay, let's see. It looks like
everything's going to be just making an announcement to everyone that because the elevator is not operable and it needs to be ADA's final to move the hearing. This court, court number 1, which is the first.
they're changing courtrooms. They're changing courtrooms. Oops. Changing courtrooms because the elevator is not working. So now the pool camera from Boston 10 had to pack everything up and relocate to a courtroom 1, which is on the first floor because the elevator isn't working. And surprised? I mean, remember the in the Karen Reed trial number 1, Norfolk Superior Court had just obtained Wi-Fi capability, I think 2 weeks before Karen Reed's first trial started. Oh, please. And I mean, can you imagine that here in Essex County, they're still trying witches as they did in 1692. I don't know why 1692. Yeah, they're moving the hearing downstairs, so we're waiting for them to reset. Thank you on top for your super sticker. Not a Haas defendant says, can they still ask if the judge and the police officer are related, or is that a moot point? Well, if she's going to have to go back in front of Judge McCarthy Neyman to get a modification of her bail conditions, like Judge Karp seems to think, it may become relevant. But that all was in the motion to recuse. And so right now it is unclear, but that's a great question. Thank you for your 5. Gigi's here. She's got my back. And she says, Justin thought Kelsey wasn't going to survive. God had a different opinion. God wins every time. Thank you for all you do, Melanie. Oh, well, you're welcome. And also, wait, where's Tiny Jesus? Tiny Jesus looks over us. Here he is. He's here. And things turn around when you have tiny Jesus. You can get your own tiny Jesuses in packs of 30. Check out my Amazon link below this show list. And I will get 10 cents maybe if you buy a pack of tiny Jesuses. But they're fun to have and give out to people. And keep one in your car, in your glove compartment. You need tiny Jesus watching over you. Mermaid Mary RN says, I emailed info regarding murder trial of Michael Hand Brockton to you and Law Girls and Attorneys in case they can stream it. And if you're interested, thank you very much. I did receive that email. I do not, because I get so many hundreds of emails a day, I can't respond to all of them. So I usually don't respond until I have a chance to look into it, and then I will respond. Thank you very much. That's a 1986 murder, right? I believe. Thank you, Mermaid Mary. And I think I look it up this morning. Is this the guy who hit her over the head with a rock? If I recall. Back in 1986. Terrible, terrible. I think she was 15 years old at the time. Okay, perfect. Thank you. Gigi's got your back, says, okay, trying this again. I just banked on Kelsey not surviving. God had a different plan. God always wins. El Diablo is about to see what karma is. El Diablo. Thank you very much, Gigi, for your 5. Bethany says, watch a special on the Depp versus Heard trial on Netflix. Kept thinking how awesome it would have been if you covered that, but the trial happened before you started your channel. That's true. That's true. But I was watching LawTube at the time. I was watching Emily Baker. Trials just aren't the same without your commentary. Oh, thank you, Bethany. You're very sweet. Many people think I interrupt too much to explain things. But that's what I do. Otherwise, it's not commentary. It's not really interesting. I mean, there's some people that stream trials on their channel and they don't even come on at all. They just restream Law and Crime on their channel and they don't even show their face at all. I don't know. I mean, maybe they do it for the chat. So their chat can be together, I guess. But I don't know. To me, why would I do that? Not a house defendant says, now we know what he was doing in the basement. Oh, you think he was looking for a stash? Oh, that's possible. That's possible. You're up on Boston 10. Are you on the website or on the YouTube? Because this is the YouTube. Okay, here we go. We're up too. We're up. Thank you. I had to refresh. All right. I spy Martha Coakley sitting at defense table. She just stood up. Let us zoom in. Aiden Carney was on his way, streaming from his car this morning. There's Kelsey's dad right there with the purple tie. This is Courtney with the beautiful silvery blonde hair. That is Tim Bradl's paralegal. And there's, I believe that's Tim Bradl. I don't know. It's hard to tell. Maybe not. They had to move to the first floor courtroom because the elevator was not working. Many supporters in the courtroom and/or Justin Aylaian's family, unclear. There's Kelsey sitting to the right of Martha Coakley. Martha Coakley's head is blocking Kelsey right now. Maybe that's also why he ripped out the surveillance system and the modem and the alarm system. But those phone calls to North Andover PD the other day, with the transcripts that we read, I'd love to hear the original recordings. Maybe at some point we will. The trial in this case is supposed to begin on the 23rd of this month, which is only about 10 days away. I believe it is next. No, I'm sorry. It is 11 days from now. It is a week from Monday, the 23rd of March. And it is slated to be perhaps a 3 to 5 day trial. Sasha's dog mom says, Justin is the pot calling the kettle. Disgraceful. Thank you, Sasha's dog mom, for your deuce. Allison says, love your show, Melanie. In my opinion, his mom wanted to be the baby's mom and needed a legal way to get him. Sickening. Very interesting that you say that. Some text messages surfaced yesterday between I haven't been able to vet them. I don't know where they came from. I don't know who got them. I know a lot of people posted them on Twitter, and many of you sent me screenshots. They're not in any court documents that I can find. They are screenshots of text messages between that's what they purport to be, between Justin's mom, Lisa, and an officer at Stow PD in Massachusetts, which is the town in which Justin's parents live, and Justin lived with his parents at the time that Kelsey was shot. The text messages show, in my opinion, how do I put this without being defamatory? An extreme case of entitlement, a sense of entitlement, and a sense of perhaps Lisa Aylaian, perhaps, was being hyperbolic in order to make some sort of record about Kelsey being dangerous. And she was asking for the police to keep driving by the house because she was very, very afraid that Kelsey's family might come after them. And you know what happened, etc. And it seemed like they were very buddy-buddy. And at one point, Lisa says to Kellie, I think it's Kellie, this officer, oh, was that you just driving by? I would love it if you would come in to catch up sometime. So it seems like they have some sort of personal relationship. We know from the, not even really deep dive, it was a shallow dive that we did into Justin's parents, that they are very familiar with the court system. They are very familiar with, and they teach other parents how to have their children involuntarily committed to rehab and such other such things as psych wards. I'm not sure who this gentleman is who's getting a close-up or who these people are in the courthouse. But if you know them, shout out to you guys if you're listening in your earbuds, wearing purple. Real sense of entitlement. And some other people say, well, no, that's common, you know, in small towns. I think there's like something like 7,000 people in Stow. It's common to call and ask for the police to do a drive-by to check on your house if, you know, you go away or something. But it has been pointed out, and many people have pointed out, that perhaps it wasn't Justin who really wanted full custody of the baby. It was his mother. They also apparently have a foster child because it was mentioned in some of the text messages that the only people, they wanted a police escort or a drive-by during the christening. Kelsey missed her baby's christening. But Justin's mom wanted someone to drive by the christening or hang out outside and watch because they were afraid Kelsey's family would show up and make trouble. And the only person allowed to come to the christening under the court order was Kelsey's sister. They didn't want any trouble. And eventually this Kellie, who was texting with Mrs. Aylaian, got a little standoffish and said, yeah, how about, I think she kind of like blew her off in the end, right? Maybe that's true, but they also have a foster child because in her request about the christening, she said the only people that are going to be there are, me, my family, my foster child, and she named her, and she said, and her family, and we don't want any trouble. We're afraid they might, it was kind of like, we're afraid they might crash the christening. Thanks, Allison, for your thoughts. Elizabeth said it had nothing to do with him wanting to protect his son. It's him wanting to control Kelsey. Justin is everything he's trying to make Kelsey out to be. What if his parents are driving the boat? I'm not saying that's true, but what if they are? They know how to work the system, apparently, because they teach other parents how to do it. I forget the name of the program that they worked for is called, but they've been quoted in several articles, even under a pseudonym. Thanks, Elizabeth. And I feel like Kelsey didn't want any of this to come out until it just got to be too much. They're really trying to paint the picture, and they have been since the beginning, of Kelsey being a crazy drunk who has no business being around a baby and who's dangerous. And the judge somehow agreed him. There's Mr. Air Quotes, everyone, James Gubitosi. He and Bradl having a couple of chuckles. Sasha's dog mom says I put Tiny Jesus on shelves in the supermarket when I shop. Yeah, it's fun to put him around so people can find him, right? Thanks for your 5. Oak Creek, Wisconsin. So if you're in Oak Creek, Wisconsin, get out there to the supermarket. You might find yourself a tiny Jesus. Kyle says your interruptions are the reasons to watch you. Oh, thank you, Kyle. Up, toe, pop it. Wait, Massachusetts has normal courtroom layouts? Yes, look at that. Look at that. The defense table and the prosecution table are right next to each other. It must be a civil courtroom instead of one of them being attached to the bench, as we often see in criminal courtrooms, such as in Norfolk County, courtroom of Judge Cannoni. Where's Kelsey? Kelsey was sitting to the right of your screen from Martha Coakley in that bench right there, next to her dad, who's in the purple tie. Maybe she stepped up to go to the ladies' room. I don't know. It's not my turn. It's not my turn to watch her. U.S. V. Ms. V. Semper Fi. It was thought Justin didn't expect Kelsey to survive. Was he disappointed she survived? Justin's going to get his. Karma's patient. Well, if it is true that he did indeed hack into her computer and access her pension documents and change the beneficiary, as has been speculated in court papers, let's just say, maybe. I don't know. I don't know that anyone thought she was going to survive. It's kind of a miracle that she did. She was shot in the chest point blank, at point blank range by Noonan. I don't know what kind of weapon he had, but she was airlifted to Mass General. She was there for 53 days. She had 5 surgeries. Her injuries, among other things, collapsed lung requiring insertion of a chest tube, several fractured ribs, lacerated liver, and other things involving, organ damage and things like that. I don't know the minute details of her medical condition, but it was not good. Jen says, betcha Kelsey's alcohol testing bail requirements were to offset her allegations of Justin's drinking problem. How connected is this guy? I don't know. But did the judge, McCarthy Neyman, overstep her boundaries or her judicial authority when she, maybe, as they're alleging, obtained information ex parte that was not in the court record, that was not presented to her? Was she considering those things in her ruling on whether or not Kelsey was dangerous? I don't know. Because she got taken off the case. Too sweet. I believe this is Kelsey right here in the brown sweater, standing behind Courtney and sitting next to her father. Thanks, Jen, for your 5. Listen, it doesn't even have to be Justin being connected. What it seems to be is North Andover PD has already been under a lot of scrutiny, right? Several lawsuits filed against Chief Gray and the department for discrimination and harassment of female officers. They had just settled a lawsuit with Sergeant Katie Gerke, the one who gave Justin permission to break into the house. They had just settled her lawsuit in December of 2025. They're bleeding money. And not convicting Kelsey, in my opinion, opens them up to potentially more litigation, more lawsuits, more judgments that may need to be paid. And when we say it should be about finding justice, or it should be about justice instead of just getting a conviction, this is one of the greatest examples that I can give you. There's a lot of holes in this story. Noonan's testimony that Kelsey ducked behind the bedroom door. There's no bedroom door. That she was kneeling and then she lunged behind the bedroom door and then she pulled out a gun, pointed it at Noonan, pulled the trigger and it clicked and didn't shoot. And then he took his weapon. He said, well, according to the officer on the first floor, Kelsey, don't do it. Kelsey, don't do it. And then shoots her point blank in the chest. Kelsey says she only pointed the gun at herself. Is there potential liability here? Oh, and then we find out that one day after this event, Noonan went AWOL. And when the department went to do a wellness check on him at his house, he said, oh, wow, I took a Flexeril and I didn't wake up. Insinuating that, or the possibility that perhaps if Officer Noonan has a pill problem and he's out there in the field and he shoots Kelsey, did that play a role in the shooting? We don't know. They're asking for the records for Noonan's disciplinary records, not just from North Andover PD, but also from Lawrence PD. And they want to know why he left. They want his disciplinary records, his IA records, if there are any. You're entitled to all of that stuff for cross-examination, for impeachment purposes, for bias. Krista says, if you didn't stop the stream to explain, I wouldn't know half of what I know legally wise. I think I may owe you some college tuition. That's okay. 10, I'll take your 10. And thank you very much for your compliment. Quilting Queen gifted a membership. Thank you. Thank you. You guys are so generous. Kelsey looks beautiful. She does. She looks beautiful. Remember, she has not seen her baby since June 30th. And her breastfeeding infant was literally ripped from her breasts. Because of Justin's ex parte order. And she's not allowed to see her baby to this day. She missed all of his developmental milestones. And for those of you who have had infants, you know how much they grow and change between the age of 4 months and a year. She's missed all of that. She'll never get that back. Missed the baby's christening, missed the baby's first birthday, and everything that happened in between. Gigi's here. Public service announcement. Do not put baby Jesus on any shelf in Massachusetts. They put you in jail for a small rubber duckies. God forbid tiny Jesus shows up. Oh, you're right, Gigi. I can't recommend that. Thanks for your 5. Semper Fi. Ms. V says, wow, he and his parents are garbage. He's a D. Respecting Ms. Melanie Little. Thank you. Thank you for the clean language. We try. Thanks for your 10. Down the rabbit hole we go. Appreciate you covering this case. Thank you for being here for 18 months. And also, been covering this since the beginning. I ain't got no quit either. They try. They really try to shut me up out there, but I don't know if the baby has taken his first steps yet. In my experience, well, tell me what it is in your experience with your babies. Did your boys walk earlier than your girls? And so I don't know, but if she did miss her baby's first steps, I mean, that's just add it to the list of things you can't put a price on, right? Holly and Johnny says, what happens to the original statement with this new narrative? Can the defense bring that up right now? Thank you for being you. The original statement of that Noonan made in Noonan's testimony, well, all of that stuff is going to go to cross-examination of Noonan because they're also going to have Noonan's grand jury testimony. And remember, she was originally charged with attempted murder with a weapon. The grand jury did not buy that. They did not indict her on that charge. So that says to me that they did not find Noonan's testimony to be credible. The only charge that she's currently facing is assault with a weapon. And with her clean record, if you exclude the charge from 2018 when she got a ticket for underage drinking, her sentence would be 5 years probation. And so she's already served more jail time than she would have with a conviction in this case. And so I don't know if they're going to bring that up today. Today, they're going to argue some of the motions that have been filed, the motions in limine. The Commonwealth. There. Oh, wait, there's Kelsey right there. Right, but brown sweater. Wait, did they just... Hold on a second. Wasn't she just sitting on the other side of the courtroom? Hold on. Did I just lose my mind? Oh, yeah. Did she move? Yeah, she moved, I guess. Now she's behind the prosecution table. And she's sitting by herself. And that makes me sad. Oh, but there's coats next to her, so maybe her dad just went to make a call. Thanks, Holly and Johnny, for hanging out with me for 4 months. And James, thank you for gifting 5 memberships. James Harrer is here. Thank you. Pink Crown says, I hope her baby remembers her. That was so sad. Oh, Beata and I have a 20-month anniversary today. Happy anniversary to us. Still love you after 20 months. Thank you. And thanks for becoming a member again. Beata L4012. Somebody said, I saw somebody, I don't know, on Instagram or something said, March 13th of 2020, Friday, March 13th of 2020 was the last day of normal. And this Friday is going to be February 13th of 2026. Maybe it will reset the clock. Maybe it'll reset the clock. Praise be. I'll allow it. Quilting Queen is here and she gifted 5 memberships because she's amazing. If you were just gifted a membership randomly by YouTube, check out the special emojis that we have. Let's see which ones we can use for Kelsey's trial. Most of them were made especially for the Karen Reed trial. I mean, we are outraged is a good one, right? And perhaps motion, granted, I'm going to make the motion myself. Boss baby emoji, we can use that for Gubatosi and his air quotes. His air quoting boss baby. Why are they cutting the camera again? Well, maybe they had to turn it off for some reason. Not a house event says my sons walked later than my Aylaian daughter. Me too. My girls were quicker walkers than boys. So I don't know if that's for everyone. Martha moved her. Okay. Thank you. So let's hope that this Friday, the 13th, we can reset the clock and pretend that the past 6 years haven't happened. And we get to be 6 years younger than we are now. Oh, please. All right, let's pull our motivational quote of the day because we do this every day because we all need a little motivation. Because who doesn't? Oh, well, this is a good one for today. Julius Caesar. I came, I saw, I conquered. I came, I saw, I conquered. All right. I don't know. Can you see it? Trust me, bro. Just trust me, bro. And we also pull motivational cards, which we'll do in a moment, or empowerment cards, I should say. Oh, my keyboard's not working. Oh, congratulations, Gabrielle.
With Ms. Healy's at the desk. Is that all right if I keep her here at the desk?
That's fine.
I appreciate it. Thank you.
And did you want your client?
All right, I'm going to take this back a moment because law girls, not attorneys, are in the courtroom and they are always out there getting it done. Always out there getting it done, all right? And the judge came in and Boston 10 shut off their camera, but not the law girls. Here we go.
Court's in session. You may be seated.
Good morning, Your Honor.
Good morning.
March 12th, 2026, Court 1, Lawrence Superior Court, the Honorable Justice Jeff Karp presiding. Calling number 3 on the courtroom 4 list, we've moved down to courtroom 1, is Como versus Kelsey Fitzsimmons, 2025, 77 CR 311, scheduled today for a final pretrial conference. With counsel, please identify themselves for the record.
Good morning, Your Honor. James Fitzsimmons, we have to come.
Good morning.
Good morning, Your Honor. Maria Moriarty, also.
Good morning.
Good morning, Your Honor. Timothy Bradl on behalf of Kelsey Fitzsimmons. And Judge, if I may, my paralegal Ms. Healy is at the desk. Is that all right if I keep her here at the desk?
That's fine.
I appreciate it. Thank you.
And did you want your client to move up? Is there room?
If there's.
There was a question of room, Your Honor. Is it all right if we put her as a
This judge is going to allow Kelsey to sit at defense table. Remember, McCarthy Neyman was like, yeah, no, she's not allowed to do that. Already he's being nicer than.
Yeah, absolutely. Sure. Whatever's comfortable. She's right with you folks.
And of course, the AG Coakley with me.
Oh, I'm sorry.
Attorney Coakley.
Good morning. Good morning, Mr. Fitzsimmons. All right, folks, let me just get my notes. So let me tell you what I have for an agenda in no particular order. So I wanted, well, somewhat in a particular order. I think it makes sense to start with the 3 Rule 17 motions filed by the defendant. What?
I may be able to shortcut you.
Oh, are you will?
Yes. Defense counsel and I have talked, and I actually spoke with Officer Noonan, who tells me he has nothing to hide. He's willing to allow the police departments to both give over his IA files if there are any. So counsel has signed a protective order that we're both going to adhere to. I just asked that you sign it, and we can get rid of 2 of those.
All right, so we'll get to that. I'm still on my agenda. You're
Noonan's, the judge is like, don't interrupt me. I have an agenda here. And Gubitosi just told us that Noonan has nothing to hide. He's going to allow it. He just wants the judge to sign orders for defense to get Noonan's records from North Andover PD and Lawrence PD.
moving too fast for Mr. Gubitosi. So, but I'm really happy and heartened to know that you folks have worked out at least 2 of the 3. I think that's great. So also.
Do you need me to boost it? Because I can boost it. Let me see if the boost will work.
On the agenda, obviously, the rest of the trial motions. I wanted to go through the penalty procedure with the mechanics of it, but also I was hoping to have a draft of the juror questionnaire for you folks today, but and I may later this afternoon. But I also wanted to need to address the defendant's what I'm calling motion to modify some a pretrial condition, paper 73, and talk about scheduling as well. So let's jump in and let me just get my notes on Rule 17. All right, so I stole Mr. Gubitosi's thunder. So you're saying that as it relates to papers 70 and 71, which are the motions related to Officer Noonan's employment records at Lawrence PD and North Andover PD, there's an agreement that's been worked out because you want to make a record of what?
Sure. I told counsel that I would, I talked to Officer Noonan. He said he had nothing to hide and he is not, and he's willing to turn over his IA files. I told counsel that I would personally reach out to the PD, request those, have Officer Noonan give them permission to turn them over. If they somehow need a court order or something, I would come before the court just to ask for a court order. But otherwise, I think we're fine there.
Okay, so all right, so that's good news. I don't want to meddle at all, but I'm just concerned that if we're running out of time, right? And we're only a week and a half away from the start of the panel, if I have it correctly. So, and I'm concerned that if an order is necessary, that it will slow down the production of it. So, does it make sense for me to issue something that would?
I'll find out today. I'll call today.
Okay.
Sign the order. Just sign the order.
And so with respect to that, we wouldn't need. We would just have a return date on the order on the summons for the records, and it would be.
If that's necessary, if they'll just turn them over to me. That's what I anticipated. That would be quicker.
Oh, okay.
And then we can litigate if it's coming in or not at some other point if there is anything.
All right, but let me make sure that we're all on the same page. Mr. Bradl,
I'm okay with that.
So you're okay understanding that the records are going to go through the district attorney's office?
I'm okay with that.
All right, and not the court. Okay. All right. And then, so you folks have proposed a protective order on the Agreed Protected Board regarding dissemination of discovery materials in empowerment of motion and affidavit. So is this broader than just the Officer Noonan's records?
No, that's just to Officer Noonan's record.
I'm going to say this because I see nothing but complaints in the chat. Complaints about the sound being distorted, complaints about the feed that we're using, complaints about NBC 10 took it off and we couldn't hear it. When I have to boost the sound, it distorts the audio. I can't, it's like one or the other. Sometimes we have to get what we get and we don't get upset as if we're in kindergarten. But now that NBC 10 Boston is back, if they're behind, I don't want to be behind. So let's see if they just decided to turn their camera back on. And their sound is hella worse.
Folks, before I turn it over to you, Mr. Bradl.
Sure.
Does the Commonwealth intend to call Mr. Aylaian at the trial?
Yes.
All right. I'll see if I can get this one boosted. And also, there's no closed captions when it's live. It's just there isn't. We only get closed captions when we're on replay. So if you're new, that's the way it works.
Okay.
Let me just refresh this and see if the booster will work better on NBC 10. Otherwise, we're going back to Law Girls.
In April or in May of 2025, where Mr. Aylaian is observed on this video.
So that's as high as
assume
NBC
that
10 will
their
boost it.
residents, at the time, smoking marijuana or something.
Yes. And then we talked that this is applicable to both Lawrence and.
This is LawTube. Law Girls boosted. You could hear Boston 10. All right. Let's rewind this a tad. If you can hear this, then fine. So Officer Noonan has agreed to allow them to get his records from Lawrence PD and North Andover PD without a fight. And DA says they're going to give it to me. And I'm going to give it to counsel. Bradl said, that's fine. There we go. I'm not a cupcake. I can't make everybody happy.
And also, essentially, if I understand this correctly, and I did review, there was video footage that you folks dropped off last night, or at the end of the day. I couldn't get the other contact to open, but I did review the video footage. But if I understand, generally speaking, that there's these multiple instances, if I remember correctly, in April or in May of 2025, where Mr. Aylaian is observed on this video. I assume that their residents at the time smoking marijuana or something.
Yes, Your Honor, that's what we would allege.
And so, and your argument is somehow this would be relevant to Mr. Aylaian's ability to perceive the events and hear the events accurately and then convict Aylaian them. So, but how was, let me ask you this, marijuana is legal, right, in Massachusetts, as is beer. So if the video displayed him, Mr. Aylaian, drinking a glass of whiskey or a beer, the number of times that you saw him.
What's the difference?
Right. What is the difference?
Happy to answer, Judge. So in this case, the state of the evidence is that we gave you 4 or 5 clips as a representative sample of over 200 clips that we have that are similar over a long period of time. And
in other words, 200 instances.
Maybe 270, I'm being a little conservative, but over 200, let's say.
All right, over 200 instances of.
What you see in the representative sample.
Okay, and what was the time period?
So the time period would go back probably a few months, Judge.
A few months before the June 30th incident?
Correct.
Okay,
Correct.
all right. And this is something that has been produced to the Commonwealth?
Yes, we sent them, and actually we got it from the surveillance that the Commonwealth had that they returned to us recently. So they definitely have everything. And so Judge, it's fair to say that there's a pervasive marijuana use by this guy. And I understand, your point that marijuana is legal in Massachusetts. It's illegal under federal law, number one. Pages 37 and 38 of the town of North Andover policy and procedures have a very comprehensive anti-drug policy for all town employees, which my brother and I were just discussing. It's a public document, and it prohibits any drug use on town property, prohibits any showing up to work under the influence of any drugs, no smoking. There's also a statute.
But what's the evidence? I get all this, I certainly understand. And I certainly understand that there's plenty of legal substances, including alcohol and marijuana, that would absolutely affect a person's ability to perceive and recall and et cetera, and testify credibly. But what is the evidence that on June 30th, at whatever time in the morning it was when this incident happened, that Mr. Aylaian was under the influence of something at that time?
So Judge, it was the afternoon, and the idea is that, the pervasiveness of the usage raises a legitimate question. And this is a discovery question. We're not talking about an admissibility question at this point. We're just talking about a discovery question. And I would venture to say that the standard there is that is something.
I'm sorry, Steve.
Yes, sir.
But the case law is clear is that this can't be, I just was reading Commonwealth versus Jones, I think, which is clear that this can't be, Rule 17 can't be used as a discovery tool. It's a tool to make the trial more efficient. In other words, you have to show that the evidence would be admissible.
Yes.
Right? So.
Well, it sort of is a discovery tool in the sense that we get the documents early. And in order to get the documents early, we have to make a showing. And I think the showing is made, Judge, in terms of relevancy of his ability to perceive and recollect. That's something that's always relevant. And so we have documented video of him smoking marijuana all over his home all the time for months, over 200 times. And so the pervasiveness of it, I would suggest, points to that there's a problem, number one. Certainly the problem with this guy. And number two, Your Honor, that there's likely to be overlap with his work schedule as a firefighter, where it would certainly come into contravention of town policy, which is page 37, 38 of the town policy, which prohibit showing up to work under the influence of marijuana. And that would trigger the further town policy, which is that if there's an incident, there should be random testing of town employees. And so we think there's a good faith basis to say, give us this early, Your Honor, that if he's been tested at work and he's tested positive at work, he's been given breaks at work, he's been put in rehab from work.
But how would that be admissible? So
They're arguing about the Rule 17 motion the defense made yesterday that we haven't had a chance to read yet, in which they are asking North Andover Fire Department to turn over all of Justin's records, including his drug testing records, his disciplinary records, his entire file. And he's right. If it can be shown that Justin has an addiction to marijuana, or he's a chronic user, it could affect his memory, right? And his ability to testify. And he could be impeached on that. And so I don't know if this judge is going to let him have it. And Bradl's argument is, look, it's whether or not we can get it right now, not whether or not we're able to use it at trial. Let's see what the judge does with this.
let's assume he, even 2 days before, on the 28th, his screening came back at his employer for positive for THC.
Sure.
Okay, so then what?
So I have a good faith basis to ask him on the stand, were you smoking when this happened? Do you remember these events accurately? Do you even know what you were doing when you were in that basement? Do you know, you're taking your baby under the influence of marijuana?
You don't think you have that good faith basis to ask that question now?
Well, there's always,
200.
I don't need to tell you, Your Honor, trial lawyers are worried about when the guy says no. And that's why it's a discovery matter in terms of, ultimately it would be a discovery matter to get this stuff. But, the lawyer is always at the mercy of someone saying no. And then if you have the backup, we can, as we say, we can prove it up. So it is relevant in that respect of us needing to know how pervasive is marijuana problem is. And we have pretty good evidence, times 200 and whatever, that it's a pretty pervasive problem. And so I think it's probably meets the relevant standard, the lack of fishing expedition. We can't get this material anywhere else. This is something that is important to make sure the cross-examination is appropriate and can be proven up. So I think my good faith basis kind of comes from being able to prove it up. And that's one way I can do that. I always have in mind, Judge.
But then I'm not sure that the records, again, but the balls and strikes that I'm being asked to call in this narrow instance under Rule 17 is keeping in mind that you're asking for me to order production of records, of employment records.
Munalo says marijuana is legal with a prescription. It doesn't matter. He's a firefighter. It's not legal for firefighters. It's against the code or their collective bargaining agreement or whatever they have at North Andover Fire Department. Would you want firefighters coming to your house who are highed up? I wouldn't.
Again, I'm not seeing how that has any materiality or relevance to what his state of mind was, Mr. Aylaian's state of mind was at the time of this incident.
Well, I think you gave me my answer when, maybe there is something in there just right up against this incident. Maybe he was under monitoring. Maybe he was reprimanded for coming in smelling like marijuana. Maybe he, had some marijuana at the fire department. We have to look at the records. I don't have a magic wand when I say, exactly what they might have, but I can point to relevancy and materiality and lack of fishing expedition by saying we have 200 something instances of him doing it over a few months. That creates the likelihood that there's some overlap with work. And then, so then we have the town policies, and then there's also another law, Judge, that's Chapter 40, Section 101A. It prohibits hiring of firefighters who smoke for pension purposes. The Commonwealth doesn't want to get into smoke or firemen. So,
Mr. Bradl, all of these statutes that, again, I don't take issue at all with. I asked that rhetorical question to start with, but I don't take issue at all with the notion that marijuana can, and especially something that's smoked off, and can affect someone's ability to perceive and then relate what they saw or heard on the stand. It's the idea of getting records that you're.
Right, but what if the records show that he failed a drug test a couple of days before this incident? Isn't that relevant? Because if he says no on the stand and the records show otherwise, he needs to be able to impeach him, right? Doesn't that make sense to you? Now, it has been shown that long-term marijuana use can affect your memory. That's a fact, right? It seems to me to be a fact. Okay. I'm not crazy, right? No, I might be. Twilight Zone emojis, please.
You are fishing for it, arguably, no? Because, hold on. Okay. Again, I'm constrained because the case law says that this is not to be used as a discovery tool. Now, let me say this. I've been there before, and I know that you're between a rock and a hard place.
Also, if he's willing to break the rules of the fire department, which could result in job loss, what else is he willing to do, right? If you know you're not supposed to stop, you're not supposed to smoke, and you do anyway, and you pee dirty or whoever they test them, and you're willing to break those rules that could risk your job, what else are you willing to lie about and do?
Because you have some information, like you do, about the possibility that they'll be in the records, but the SJC has made it clear that you need more, I believe.
So you're the judge, and I respect your ruling, but I should just say.
Well, I haven't ruled yet. So
I appreciate it.
And that's why they gave him video. That's why they gave him video, because they do have proof. They do have a good faith basis to ask for this. I disagree, but I don't know what he's going to do.
My thought is that whole business about it not being a fishing expedition, I think that what they mean there is that you can't be held, the defense can't be held to the standard of knowing what the other people have without getting to it. It would be easy if we could say, I know they have 16 reports from 16 days that he showed up smelling like marijuana and stumbling around. But, you know, that's never the case because this is adversarial litigation. And so we don't know, and we never do know. So the courts can't put the defense in this catch-22. We have to ask for the records, and it can't be a situation where, you know, you have a time machine, you have a magic wand, whatever you want to call it. You know, we don't know. Defense counsels never know. And that, it can't mean that Rule 17 means nothing. So you have to interpret this fishing expedition thing as meaning just completely throwing darts. And so what I'd answer to say why we don't have a fishing expedition here is because, excuse me, we have this incredible number of video documentation. And we know that he's a full-time firefighter in the town. And so the likelihood of an overlap is pretty substantial. So that's really all we have. And that's all the defense counsel can ever have is kind of skirting around the edges.
And in fact, you know, arguably you have more than we often see, right?
I think so. I think so, Judge. So, you know, this is just, you know, this is asking for records that will potentially be able to give me the ability to prove up a denial, I think, if you will. And, you know, who knows what he's going to say? I don't know, because he's an adversary. So I'm just trying to get the record as populated as possible. And if I have information, I'll know the parameters of what he's saying is truthful and what is not truthful. And I think it would make for a better cross-examination and a more economic cross-examination if I'm not dancing all around without the benefit of these records. So that'd be my argument, Judge. Thank you.
Well, I think I just echo much of what you said, and so I hate to do that, but, and echo what he said. He said, maybe, we don't know. That's
What he said? Who's he? The cat's mother? My brother, counselor? What Mr. Bradl said? What he said? This guy really gets on my last nerve.
the definition of a fishing expedition. That's the definition of a discovery tool, and that's what he's looking for. And he admitted it. He has a basis to ask that question. He could ask the witness on the stand, were you under the influence, or had you smoked, or anything like that? He has a good faith basis to do that. I wouldn't object to that question. I think it's a fair question based on the landscape that we have here. And the answer is what the answer is. And that's often the case. So I would suggest to you, he has not met his burden, and the court should deny the motion.
Mr. Bradl, anything else?
No, Your Honor, thank you.
No, on that.
No, that's all I have for that, yes.
So I'm going to issue a more formal ruling later, but the motion is denied because the defendant has not met her threshold requirement under the land pond protocol. And as I said, I'll be more specific in my written ruling later.
Well, they gave you video.
Right.
They give you video not only of him smoking something that appears to be weed and her affidavit that says all of the things that he did in the acid and all of that other stuff. But there's also video of him breaking into her house. So he's not, he's also potentially would be in any other county facing multiple felonies for breaking and entering and stealing her computer and her passport and transferring money and doing all of those other things, which also go to his credibility, right? But they're not going to charge him because they've already said, the prosecutor said, we're not going to charge him on that stuff because, you know, I mean, listen, he's a witness, but he's not a recipient witness. He didn't actually see the shooting, even though he was in the basement and ran away when he heard the gunshots, because he's the only first responder in history who runs away from danger instead of towards it, right? We're not going to prosecute him. But if he takes the stand and he takes the fifth, we'll immunize him, Judge. We'll just immunize him. We're not going to prosecute him. This goes so deep, you guys, so deep.
moves us to.
Yes, they can appeal that ruling. Remember in Karen Reed, they did for the phone records of Brian
So,
Albert.
I thought we would
and
then
McCabe.
go to the defendant's motion in limine, which has various requests. Let me just get it from the paper 67. Now, I meant to point this out even before we started on the Rule 17 motions, but I think it's worth saying. So, Mr. Gubitosi, at the last hearing, you said this is something to the effect, I mean, probably more eloquently than I can remember, but something to the effect of that this is a very simple case, straightforward about what happened in the bedroom. And I'm glad to see that the defense seems to agree, because in in this particular motion, Mr. Bradl, you wrote, the narrow issue here is whether Ms. Fitzsimmons committed an assault with a dangerous weapon against Patrick Noonan on June 30, 2025 in the bedroom, et cetera, et cetera. So I point out that you folks agree. So that's my thinking here, to trying to keep things simple when I'm addressing all of your motions and your trial motions and your requests. I agree that we at least have an agreement on a starting place. But let me hear you, let me ask the Commonwealth on the defendant's motion. So as for sequestration, let me say this, I typically don't issue sequestration orders like formally. In other words, I would now ask the Commonwealth, I would just rely on if there's an order in place for you folks, both sides, to tell your witnesses that how it works. So does the Commonwealth object to a reciprocal sequestration? In other words, yes? Okay. Thank you. So I'm going to allow the request that the trial witnesses be sequestered as that term is used in your motion, and it will apply to both sides. So I would, you'll be responsible in conveying to your witnesses that particular order, that they're not to discuss their testimony with other witnesses. All right, and on number 2, the
Sequestration is keeping all trial witnesses out of the courtroom during other people's testimony and also not discussing the case.
opinion terms. So I almost always use people's names, their surname. It's very possible, if not probable, that I would use a term like alleged victim, who I believe would theoretically be, not theoretically, would be Officer Noonan. Thoughts?
The Commonwealth has no objection to number 2, so long as it also is binding on defense counsel.
Meaning what?
He also got referred to anyone as victim, suspect, target.
Right. So are both sides okay with alleged victim?
Yes.
Of course, yes.
Okay. All right. So I'll allow that, and I'll write this up later so that we're not. And number 3 is basically a motion to preclude prior bad acts or other acts. And let me say this: it probably makes sense to hold off on this because I view this as an opposition to a couple of the Commonwealth's motions, I think. So just remind me to straight and we'll circle back if I haven't addressed everything.
Certainly.
In there. Number 4 is voir dire. Let me hold off on that for a moment because the Commonwealth also has voir dire, proposed voir dire. But let's go to number 5, which is the last. So number 5 is that the court exclude. There's a lot there. Commonwealth
I mean, I think most of it is not really applicable to the facts of this case. So insofar as, you know, the defendant is known to other members of the North Andover Police Department because she was a North Andover police officer, I think that's kind of unavoidable. They're
But not a
literally-
repeat offender, that's what I'm.
Certainly not repeat offender. And I think the defendant never fled anywhere. She was never a target of any, you know, broader investigation. So I think as this is somewhat boilerplate, it doesn't really apply to the case, so there's no objection.
All right, so that will be marked as allowed of objection. And we really should at some point talk about, and this may arise during the hearing on one of your Commonwealth's motions, but talk about the scope of what the evidence will be as it relates to this 209A work, right? And I think we need to flesh that out, or maybe it doesn't need to be fleshed out. But we'll get to that in a moment. So that leaves paragraph 4 in the defendant's motion, which is request for a voir dire. And while I'm addressing the defendant's request for voir dire questions of jurors, let me get the Commonwealth's out. Paper 63 is the Commonwealth's request for jury questions. So let's just go back for a moment. As I said, I intend to handle this impanelment like I do all impanelments, and that is to use a case-specific juror questionnaire in addition to the single-page questionnaire that the jury commissioner issues with the summons. So my philosophy is, and also you folks will have, we will conduct individual voir dire of every juror, whether they answer yes to any of the questions or not. You folks will have permission to ask reasonable questions as part of attorney conducted voir dire. My philosophy is to put as much of the questions you folks think are relevant in the questionnaire, so that it just will speed up the process. Obviously, you'll have your own things that you'll want to maybe ask personally, which means that the questions have to be formulated in a yes or no, in a manner that calls for a yes or no answer. So when I look at the defendant's request, I mean, I definitely can include something like A and B, C, mental health issues in general, and yeah, D will be in there, E will be in there. Yeah, F I don't ask, I'm not saying that you can't, but same thing with G. I mean, there's obviously versions of F and G when they're asked whether they can obey the idea of the presumption of innocence and reasonable doubt, etc. Same thing with H and I and J. So all of those things are kind of covered, but you'll be free to ask follow-up questions or questions that are that pertain to that. Now, so on the K, I'll formulate something. Does it make sense to have some kind of question related to groups such as, I don't know if this is still pertinent, this is from years ago, fathers' rights groups, groups that may advocate for Second Amendment issues. I don't know, things of that nature. They could be grouped together, but I think K is too broad. So I'd be amenable to, again, asking for, you know, if they've ever, if a juror, potential jurors ever donated to or volunteered for a domestic violence related organization, or if that's what folks think, or some kind of a parenting, shared parenting organization related to that.
Yes, I think we should do something like that. I trust your judgment.
Okay, so on the Commonwealth's and paper 63, I think I cover almost all of this, at least on the first page. Second page. So it does make sense to ask about, as the defense requested, suicide, mental health, in general, postpartum, even. I can formulate some questions related to that. Training and experience with mental health issues. I don't know, is mental health going to be a issue? Well, it's going to come up at some point, right? Even on a limited basis.
I think it's going to be very tangential. You know, I think it's really more about, and actually, my brother and I just hatched out an agreement that the way that this was served, as they all are, is without an affidavit. It was just served, the order was served. And I think we have a stipulation that we can just admit what was served, the restraining order. And the terms of the restraining order are what we both, literally we just discussed this, what we both are interested in utilizing. So I think that will probably cover the issues that we both are concerned about without opening too many doors on either side.
So I guess the question is,
They're arguing about what questions should be asked of the jurors during jury selection. What questions should be asked individually of each juror. And he did say he would allow individual voir dire, which is good, because sometimes if you're sitting in a large group and a question is asked such as, does anybody do any of you have any history of, or have you been a victim of, or has anyone in your family been a victim of domestic violence, let's just say. Some people might not want to raise their paddle because they may be embarrassed or for whatever reason. And so the fact that he's going to do it individually is a good thing.
do you think I should stay away from 8, 9, and 10, and 11? Or do you, that being on the Commonwealth's request, or do you think that those things are worth asking about?
So I have an objection to 8, 9, and 10, because I think it's kind of suggesting things that aren't going to come up. You know, mental health disorders, I don't think that's really going to be something that's going to be discussed at this trial. Or
But you folks are asking about suicide, so wouldn't that beg the question? No? I mean, obviously there's many reasons that people commit suicide.
Not necessarily, you know, it's I don't want to invite some sort of wide-ranging exploration of, you know, Ms. Fitzsimmons' medical history. And not to suggest there really is anything that's, you know, awful. I mean, we have postpartum depression. Whether that becomes an issue in this case, I don't expect so. I think she was served with an order that did 4 incredible things to her life and would do 4 incredible things to anybody's psyche. She lost her 4-month-old child in completely out of the blue. She's home with her baby in sweatpants having fun. She loses her 4-month-old child. She's betrayed by her fiancé. Her marriage is over, ain't gonna happen necessarily. And you can picture her sort of almost having this realization. Her job's over, her guns are gone. Again, she just got them back. There was a 100-page report clearing her of anything and putting her back at work. She was going on the schedule in 3 or 4 days. And the other thing is that she was completely humiliated in front of her own work friends and colleagues. So I don't think we need to really go to dig up any sort of diagnoses, especially something as common and, you know, expected in a woman as postpartum depression as a reason for wanting to just end it all in a brief, half-hearted minute.
So the bottom line is you object, the defendant objects to 8, 9, 10. How about, a letter, just the training related to mental health?
That one, we're okay with that.
All right, so 8 to 10, so let's just take them a bit at a time. Commonwealth, from your perspective as to 8, 9, and 10.
Obviously, we cannot predict how the trial is going to proceed. However, based on counsel's representations here and prior public representations, it seems like the defense is going to be that based on the confluence of those 4 factors, the defendant claims that she was attempting a suicide attempt. I don't know how you divorce suicide from mental health issues. I think that the two are one and the same. When someone hears suicide, particularly in a jury pool, they're going to think mental health. I think it's going to come up that why did Justin have it, it's not guaranteed to come up, but the fact of the 209A order suggests that there was a reason why a neutral magistrate determined that Mr. Aylaian should have custody of the child. So I think mental health is a...
She just called him Alien. Mr. Aylaian. Let's hear that again. It's Aylaian, but he got really mad when people started calling him Alien. Didn't he try and get some channels stricken, perhaps? Listen again.
They're going to think mental health. I think it's going to come up that why did Justin have it, it's not guaranteed to come up, but the fact of the 209A order suggests that there was a reason why a neutral magistrate determined that Mr. Aylaian should have custody of the child. So I think mental health is an integral part of the case. The Commonwealth is not shying away from that. I think that we need to ask the jury about it because depending on how this trial goes, it could be very narrow. It could be a one-day-long trial. It could be much longer, depending on how things go. So I think we need to really probe the jury and find out what any biases that they may or may not have with respect to mental health in general.
Okay, mental health is an easier concept broadly because it's been raised somewhat by the suicide request by the defendant. But as for specifics related to postpartum, so does the Commonwealth believe just in your case in chief that that would somehow come out?
No, but I mean, there are signs outside talking about postpartum depression is not a crime. So it would be.
And in the end, how come I remember? I'm surprised that this, Mr. Bradl, the postpartum depression is controversial from the defendant's end because I thought I read in some submission somewhere that was a fact from your perspective, right?
So as we're evolving kind of towards trial, Your Honor, you know, it occurs to me that the case is really doesn't matter much about why the person got an order, what was going on with these people. You know, the police are serving an order. That's their legal duty. It doesn't matter what the order says or how it was gotten, or whether it's based on truthful information or fraudulent information. They have a duty to serve an order. You know,
Okay, but let me ask you.
But wouldn't, and you correct me if I'm wrong, wouldn't postpartum depression make you more likely to take your own life instead of someone else's? Wouldn't it be more likely that if she was suffering again from postpartum depression that she would be turning the gun on herself and not Noonan? I don't know. I guess we need an expert for that. But it seems to me like that might be good for the defense. What say you?
Tell me the facts about the service, the actual service of the order. And that is that, does the Commonwealth believe that the evidence will be that the defendant read the order and understood it before, in other words, processed it somehow and before the shoot?
Yes,
Okay.
to process the order, not the affidavit.
Because the affidavit wasn't there. All right, so Mr. Bradl, presumably, and you said this, is that your client's state of mind is significant, right?
Right.
Because she has to have intent, right? And there was some mention in some filings about perhaps she's pointing the gun at herself. You asked about the suicide attempt. So
So my-
failing to see how just asking a question about postpartum depression somehow prejudices the defendant.
my
I'm
thought
not
is,
suggesting that it would be admissible or not,
Right.
it's just a question.
right, I mean, I'm concerned about the degree of disclosure, and I feel like, you know, the second it gets mentioned, that the government's gonna allege that we've opened the door to something, and that all of her prior incidents are relevant, and now they have to come in about postpartum depression. So, you know, where I have an order that did those things that I just recited a few minutes ago, I don't really think that, you know, we don't need to gild the lily here on, you know, and on top of that, she had a bit of postpartum depression. Like, I mean, how far do I have to go? I mean, those things that I said are eye-popping. To have that happen to anybody out of the blue on a nice summer day when you're home with your baby.
Especially if they're suffering from mental health
I agree.
or conditions.
I agree, but I don't want to open the door, and if
You're not, so let's be clear.
okay.
We still need to drill down on, at least I think we do, on what is admissible broadly in this
Right.
area. All I'm addressing right now is the simple yes or no question related to postpartum depression. And that is whether they have any experience. I could use something similar to, Ms. Moriarty, were you in the Brito case, you know, where there was a significant mental health issue or issues. And it would just be yes or no. It's not, I would never say, there'll be evidence that the defendant, I don't know, it's just your experience with it.
You're giving me a comfort level, Judge, and I'm okay.
Oh, okay, but the other thing too is just understand this, is that I'm gonna take the information that we gleaned, that we discuss now, put it in a draft of a questionnaire that we'll go over before it's disseminated, and you'll have an opportunity to see exactly what it is I'm asking. I was hoping that would be today, before they're disseminated. Before I forget, while we're talking about, so give me an opportunity to
Okay,
put that in there.
I'm okay with it,
And
just
just
give me a comfort level, Judge. I'm okay.
Okay, you don't need to be comfortable, all you have to be comfortable is that it's gonna be in the draft, and you'll have an opportunity to see exactly what
All right,
I
thank
want to ask, and that's for all of these questions. But can I hate to float around, but one of the issues I have is related to the draft of the juror questionnaire, is I think that there's obviously media attention to this case, there's public attention, the public and the media have a right to and the defendant to a public and fair trial. I'm concerned about having a draft of the juror questionnaire getting out there by mistake or et cetera. So I'd be inclined to simply impound it, disseminate it for your eyes only, for, you know, obviously to provide show to your client, and just impound it until we get to, and then we can talk about what we do with the final one as well. Any objections to that from either side?
No, I think it's a great idea.
Okay, all right, so, that's the way Mr. Williams makes sense of money, that's the way we'll handle that. All right, so
Okay, so he's going to impound the jury questionnaire because he's right. I mean, documents have been leaking. They've been leaking.
I think that, does that cover everything? I think firearms related questions in Second Amendment type of stuff that I typically ask in a firearm possession case would be pertinent. Again, why don't you folks just with an open mind, take a look at what I write, what I draft, and you can object or take it out. Let me just look at the rest of this. Yeah, all of the rest of the questions would be included.
Your Honor, if I may add one that was not written.
Sure.
If you are going to reference at least how defense counsel has it phrased, there may be references to suicide attempt. I think that is a way that gets the jury comfortable with the defendant's theory of the case. The Commonwealth would ask if that's the way it's phrased, that.
No, I'm shaking my head because it's not going, it won't be phrased like that. At least initially when I drafted, I think that all of these questions have to be neutral. They have to be neutral to both sides, in fairness, but more importantly, again, it's not, I don't like asking questions that are case specific. The evidence may show, because it may not. So the issue is whether they have a personal experience with suicide, all right? Again, from the defense perspective, and that's what they'll be asked, something like that.
I would just like to raise the point of suicide suggests that the person committed a violent act themselves. The Commonwealth, one of the Commonwealth theories may be that it is an intended suicide by talk. So that,
Oh, okay.
so I just think that if Your Honor can consider that when drafting your jury questions.
Oh, so in other words, you'd like to, perhaps a question that would cover so-called suicide by cop?
Yes, sir.
Right, so,
Thank you.
just, I'm not sure that I'm that creative. I'll have the ability to artfully draft something like that, but we'll put a placeholder in here. I'll do the best I can, and you folks will.
Just to chime in on that,
Sure.
I'm not crazy about that because it's too specific, too suggestive, and it just adopts the Commonwealth theories. So I think the topical reference should be where it begins and ends. Just put my position.
Okay, so it seems to me that they're going to be asked, like in any serious case, whether they or a person close to them have been a victim of a violent crime. So typically I ask that, maybe, or been accused of perpetrating a violent crime. Maybe it needs to be shooting related, that question. Or firearm related or something, but again, I'll draft a few questions that I think are appropriate. Folks will weigh in and we'll hammer them out. Anything else, just generally on what here, on the jury questionnaire? Nothing. And then, what else did I want to say about I have to tell you, from my perspective, you folks tell me you know your case better than I do. I think that the impanelment will take 2 to 3 times as long as the trial.
Oh,
I just, and
the trial's only supposed to be, I think, 3 to 5 days. So he thinks that the jury selection is going to be like 6 to 10 days. That's interesting.
And I just would, I'd really urge you folks from taking a look you probably have at the rules of professional conduct as it relates to trial publicity, and just do your best to make sure that we can get from the start a pool of potential jurors that are indifferent to the extent that we're able to. But I hope I'm wrong, but I really think that the panel will get 14. I don't know. Anyone disagree?
I think that just depends on, but he potentially opens the door to.
The judge is just reminding them of their ethical obligations pre-trial, because I think the judge's concern is that by the time we start to pick a jury, too many people are going to have heard about this case from the media, and too many people are going to have already formulated opinions about this case, and they're going to be disqualified. So remember the code of ethics, counselors, and guide your actions accordingly with your pre-trial publicity. I mean, it's a good point.
About how long the trial will be.
Okay, yeah, I'm not really understanding that, but I'm not sure that I need to. So let me talk a little bit about scheduling. So I'm going to assume that we start handling on the 23rd. We get jurors here in Lawrence on Monday, Tuesday, Wednesday, Thursday. We get the most jurors on Monday, and then the amount that we get are less than each day. I think that we should assume that it will take through Thursday, and that the trial, I should tell the jurors, perhaps even in the questionnaire, that the trial would start on Friday or even the following Monday. I know you tell
We
me.
can think about that only because we only got 6 challenges each. So, that sometimes makes a difference. I understand other challenges that we will be dealing with, obviously, as far as people knowing about the case and reading about the case and the like, but
Let me raise the number of challenges because I gotta get my water from you because the last handful of trials I've been like felonies, where folks get more. But my memory is that on the criminal side, you get 4 and 1 extra if there's going to be any extra seated jurors. Frankly, whatever the rule says, I'm going to give you. I know. The council oftentimes tell me, well, in Essex County, judges typically do X amount. I don't care. Whatever the rule is, and I don't have it in front of me. I think it's 5.
but we were just talking, I thought it was 4 and then a challenge for each extra juror. Of course, each alternate juror, so.
All right. I don't have my, but whatever we'll all research.
I agree with that, Judge. And then if there are 2 alternates, we get 2 more, so there's, typically 6.
I don't think that's.
Whatever you want.
I don't think the rule, I think the rule is for any that are over and above the 12, you get 1 more when it's not a light felony. But again, it will be 5 or 6.
They're talking about peremptory challenges, meaning that each attorney has the right to strike any juror that they don't like for any reason. They get 4 each. And then the judge is saying, because it's not a life felony, you'll get 1 each for alternates. And jurors can be dismissed for cause if the attorneys agree and the judge agrees, and you don't have to use a peremptory for that. But that's what they're talking about right now.
Figure that out. But as for I need to tell the jurors the start date, and I also need to tell the jurors an expected end date for them to get that, when they'll get the case. So what I was going to propose is that they be told that the trial would start again on the actual trial, the evidence would start on that Friday or even following Monday, and that they would get the case by the following Friday, April 3rd, which is over estimating the length of the trial on purpose, so that we have built-in time.
Sure, I think we don't want someone going away. I totally agree with you. I don't know if it's going to take that many days. Maybe I'm being naive to find a jury.
Okay.
So, but we can maybe see where it goes. I mean, I think maybe we say we start on Thursday. And think about the day.
Okay. Yeah, we can even tell them that we'll start on Wednesday or something. And see. I'm surprised. But don't be surprised when we get a draft of the juror questionnaire that it says that I estimate that the jury will get the case to begin their deliberations. I'm just going to probably just default to April 3rd, which is Friday, because then in the next sentence I'll say that therefore you should be available to serve the following week. Case that lasts longer. So let's talk about, in this meeting, we have more motions which we'll address. And this may be the subject of, let's talk from the Commonwealth's perspective. I'm trying to get a handle on what exactly the evidence will be related to the purpose of the police being there, how much you expect to get in during your case in chief about this custody issue that was ordered, et cetera?
Well, the underlying facts that I expect to come out is that a restraining order was sought. Mr. Aylaian was.
He called him Aylaian too.
He
called him Aylaian too. That's funny. Yeah, that's true. Turtleboy's mega motion is on March 27th, and Bradl would typically need to appear for that. I wonder if, sometimes they can work it out. That's supposed to be, I think, at 9:30 in the morning. Sometimes they can work it out, although I don't know how far it is from Dedham to Lawrence, or maybe Better can handle it that day. We'll see. We'll work it out. I'm sure they'll work it out.
Restraining order to the officers, 3 officers.
Gotta take it back.
Aylaian was at the PD. A restraining order was,
Et cetera.
well, the underlying facts that I expect to come out is.
Okay, here's his theory of the case. Here's his underlying facts as he sees them. Gubatosi's telling us everything.
That a restraining order was sought. Mr. Aylaian was at the PD. He gave the restraining order to the officers. 3 officers went over to the house. He stayed back until they called him to come get the child. They called him. He went. Was in the process of gathering things. The officers went upstairs after serving the restraining order and explaining what was happening to the defendant. The shooting occurred. The end. So I don't.
The end. The end. Wasn't the end, because Kelsey's still alive and she's sitting across from you in the, well, she's not at the table, I don't think, the defense box. It's wild to me that they had Justin in the house while this whole thing was going on. It's just wild to me. He had a restraining order against Kelsey. He wasn't supposed to be anywhere near her. Why was he in the house? Why did they allow him to be in the house? Why didn't they have someone else there to pick up the baby? I don't know, someone from DCF or CPS or whatever you call it there in Massachusetts. Insane.
Anticipate getting into more than, or the jury really hearing more than that in the Commonwealth's case in chief.
Okay.
Subject to many of the motions that we have filed.
So
If the doors are-
maybe it makes sense to, let's start with paper 61 because this kind of segues into that. And that is the Commonwealth's motion to eliminate to prohibit questions regarding custody status. And actually, when you say custody status, you mean both the child custody and the pretrial detention aspect.
I do actually.
Okay. All right. So let me first, before I hear from you, Ms. Moriarty, is there an objection to either one of these items in paper 61?
We don't expect to be employing anything down that road about custody.
About either custody, about the custody issue related to the child, and about their client's
Well,
detention?
only to the extent of the contents of the order that's being put in front of her, and that to the extent that it's just an obvious part of the whole thing is that,
Right.
she's packing a bag for her baby, she's giving the baby to the police, to give to the father, just what's in the order. I think we're probably in good shape on that in the sense that we're both agreeing, we're going to stipulate to the order, I think, as an exhibit, and the order says what it says, and we're going to both use what it says on the order.
Okay.
So I think that's the extent that I.
All right. So obviously, you can argue and question witnesses based on reasonable inferences from the order, but doesn't the order mention custody, temporary custody? Do you folks have, is there a copy of the order? And I thought I saw it on the file.
So I think just the custody post June 30th, 2025. So insofar as the child is still with Mr. Aylaian, I don't see how that's relevant. That was really so the fact of the fact.
She corrected his name. She got it right this time.
We're not disputing the fact of the matter is the 209A order granted Mr. Aylaian custody of the child that day. We just didn't want there to be additional on direct or cross of any witness, you know, the current custody status of the child.
Okay, I can't imagine you want that.
We don't.
Okay, all right, so, and then do you anticipate, Mr. Bradl, that you would raise your client's pretrial detention status?
Yeah.
All right, so then it seems to me that I can allow the motion without objection, as it is narrowly tailored. So, just,
This is Judge Karp, K-A-R-P.
so then that brings us to paper 62. Commonwealth's motion in limine to preclude questioning regarding current duty status. So let me be more specific. My understanding is that you're seeking, Commonwealth is seeking to preclude evidence regarding the Officer Noonan's now current status with the North Andover Police Department?
Yes, sir.
Okay. And what is the status?
The Commonwealth's understanding is that he is on leave.
Oh. Did you see the way she said that? Very hesitantly. What is his current status, Officer Noonan? He's on leave. And that's all she's going to say. Why is he on leave? Why is Noonan on leave? Look at the judge's face. Listen to that again.
And what is the status?
The Commonwealth's understanding is that he is on leave.
Oh. Oh.
All right, so
Tell us more.
you would want to preclude any mention about that Officer Noonan is on leave?
Yes.
Okay. What do you say, Mr. Bradl?
Judge, I think that we're just talking here about perhaps putting this in abeyance until we get the IUD files, because we have a lot of information that I think we have more information than the Commonwealth, frankly, about his status, that it may direct this debate in a better way.
Yeah, maybe I just.
Due to drugs. At the beginning of this hearing, when they first started arguing the Rule 17 motion to get Officer Noonan's records from North Andover PD and Lawrence PD, the Gubitosi got up and said, Officer Noonan has nothing to hide. He will consent to you obtaining his records. And so now we find out he's on leave. And of course, we all want to know why. No, not because he shot a citizen. Well, first of all, she's a fellow police officer, but he did go back to work after that because we saw some paperwork on that. Then he was AWOL. North Andover PD went to do a wellness check on him. And he said, oh, sorry, I took a Flexeril and I didn't wake up in time to come to work. So it's going to be interesting to see why he's on leave. Bradl says we know more than they do. Stay tuned for that. Put a pin in that.
Defer ruling.
I think that makes sense, and we can address all the issues kind of simultaneously.
Okay. So that brings us to paper 64, defendant, respect that Commonwealth's motion in limine to admit prior bad acts if they become relevant. There's also some good acts on another motion, but go ahead.
With respect to the prior bad acts evidence, Your Honor, as captioned, the Commonwealth recognizes that those are not relevant to the Commonwealth's case in chief. However, in abundance of caution, the Commonwealth wanted to alert the court to evidence it had in its possession about prior bad acts in case they do become relevant based on opening, cross, or the defendant's case. So we can really hold those aside for now, but the Commonwealth just wanted to alert the court. And obviously, if the Commonwealth believed that a door was open, we would come up to sidebar before any questioning related to any of these issues.
Okay, so and I appreciate that you're being careful. So the bottom line is you're not seeking, the Commonwealth is not seeking at this moment to admit other acts, but you may argue, as either side would argue during the course of the trial, if it arises that the door has been opened, and we'll have to address it at that time.
Yes, sir.
All right, so I'm not going to take any action
That's
on it.
fine.
No, that's easy. It will be deferred until is necessary, which brings us to paper 65. This is Commonwealth's motion in limine to preclude questioning regarding promises, rewards, or inducements.
This is the good one. So if your mind has started to wander, come on back. Come on back. This is the motion in which the Commonwealth says Justin didn't do anything wrong. He didn't break into the house. Here's all the transcripts from all the 911 calls when he called North Andover PD. And here's the people that he spoke to. And here's the conversations that he had with them. We're not going to prosecute him because he didn't commit any crimes. Come on back for this one.
And I'll hear you comment on that.
And this is the subject that we touched on last time.
Right.
Just concerning the request for a promise, reward, or inducement. And so I think we're kind of in a slippery slope, because if the council is able to ask the witness concerning post-event accusations, because these accusations that the defendant has made in unsworn statements and the like is going to muddy the waters. One thing that
But which accusations are you talking about? The accusations related to Mr. Aylaian allegedly breaking into the house, or the accusations about purported favorable treatment of Officer
I'm sorry, this is the alleged breaking and entering.
Okay.
And because it is post what we're talking about here, the Commonwealth has stated on the record, we're not pursuing that, and we're not pursuing that, it's based on our prosecutorial discretion, but honestly, with our prosecutorial ethics. This is these are allegations that were made by the defendant in unsworn statements that the Commonwealth believes many of them are just false.
Okay, listen to the word salad. You are ethically prohibited from prosecuting Justin because you have a conflict of interest. He is a witness for the Commonwealth in a very, very important case involving an officer, a double officer involved shooting, right? One officer from North Andover shooting another officer from North Andover. The shooting victim is the one on trial here. You have a conflict. The case was originally sent from Essex to Middlesex County. Middlesex County said, we can't touch this because we have a conflict, because Martha Coakley, look at Courtney's face, Martha Coakley used to work for our office. So they sent it back to Essex, where the DA is Paul Tucker. And now this man is going to tell us why he thinks they can't prosecute Justin, because they don't think there's a crime here. I'm taking this back a tiny bit so that he can tell us everything about why he doesn't think ethically he should have to prosecute Justin. This is insane. Let's hear the beginning of his argument. Here we go.
We're kind of in a slippery slope, because if the council is able to ask the witness concerning post-event accusations, because these accusations that the defendant has made in unsworn statements and the like.
He tampered with evidence, sir. He took a letter off the refrigerator that he wrote to Kelsey telling her what a great mom she was. And your response to that was, well, you know, crime scene took a photo of that letter and we've exchanged it with the defense and evidence. So not a crime. Not a crime. In addition to the breaking and entry, busting the door down, he didn't have a key, disabling the alarm system, ripping out the security system, ripping the modem off the wall, taking her laptop, her passport, using it at his parents' house to commit maybe bank and wire fraud. stealing her passport. And because it's in an unsworn affidavit from Kelsey, you got a problem with it? You have never even spoken to Justin. You said that at the last hearing. You've never even interviewed him about this. It's all on video. And apparently, one of your North Andover officers responded to the scene to allegedly separate Steve Fitzsimmons and Justin Aylaian. But in your papers, you said that they hugged it out. Dude. All right, I'm going to let him talk now. But keep all of that stuff that I just told you in mind.
Is going to muddy the waters. One thing that
But which accusations are you talking about? The accusations related to Mr. Aylaian allegedly breaking into the house, or the accusations about purported favorable treatment of Officer, remind me.
I'm sorry, this is the alleged breaking and entering.
Okay.
Okay. Because it is post what we're talking about here, the Commonwealth has stated on the record, we're not pursuing that, and we're not pursuing that. Not it's based on our prosecutorial discretion, but honestly, with our prosecutorial ethics. This is these are allegations that were made by the defendant in unsworn statements that the Commonwealth believes many of them are just false.
That's not your ethical problem. Your ethical problem is conflict of interest, counselor. Not just because you think they're false when you never really even investigated them. And doesn't what happened after also go to motive of Justin? Justin and his fake maybe application in family court is exactly what led to this chain of events, sir. And again, Courtney's face.
Mr. Aylaian was a resident of that home.
All right, hold on.
Yep.
I'm hoping that we don't have to relitigate or even litigate for the first time the alleged conduct. The bottom line is the Commonwealth is seeking to preclude mention, Mr. Bradl, of the events of this breaking and entering. Okay, and do you object to that?
So I don't expect this trial to go down this side road. But to the extent, I don't think Aylaian really is a relevant witness in the case. Granted, he's on the premises, but he has marginal relevance. And I think that
It's kind of, that's what Mr. Kubikosi said at the last hearing, but you didn't seem to agree. So maybe you rethought it.
he's a dangerous witness, I think, for both sides. Let's put it that way. And so it's a complicated scenario, Your Honor, that, if he does testify, that opens cross-examination. That might open some other doors too. But, I mean, if it was me, I don't think I would call Mr. Aylaian, because it opens up all kinds of cans of worms, and he has testimony that's only duplicative of other people. And, the fact that he's there on the premises, let's put that aside for a minute, that they let the guy who gets an order to have someone stay away from him, they bring him to that premises. Let's put that aside for a second. But he's like a straw man. There's nothing that he adds to the trial, and I'm going to cross-examine him, but I don't want to open up certain doors. So he's a very complicated witness. He's one of those kind of mistrial witnesses. So I don't know why they're calling him, frankly. But if they could, this is, I guess, my position. If they call him, then all bets are off.
So I can't imagine that you're asking me to.
Exactly. They want it out because he needs to be charged and they aren't doing it. And now the public knows, the public is outraged. All of Justin and his testimony and his breaking and entering and everything is better suited for family court, right? When it comes to custody issues and things like that. And Bradl is now telling us everything. It's already out there. Kubikosi has already said numerous times they're not prosecuting him because ethically they don't think it's a crime. Good. The public is outraged. There's going to be ramifications for that. It's all going to come in family court. But again, like Bradl just said, I don't even know why they're calling him. It could be a mistrial witness for them. Interesting strategy. And that's exactly what they're looking at. And this female court officer is all of us right now. Come to your screen to see her if you can. I know all of you want to see Justin testify, but we'll see what happens, because if the Commonwealth doesn't call him to testify, you know Bradl's going to use that in his closing too.
The Commonwealth
Let's take it back a second to the beginning of his comments.
And all bets are off.
So, I can't imagine that you're asking me to preclude the Commonwealth from calling
No,
witness.
not at all.
The Commonwealth has a burden of proof, and they're
Not
gonna, within the rules of law and evidence, they're entitled to try to prove their case, just as Ms. Fitzsimmons is. The issue is, do you intend to ask Mr. Aylaian, if he testifies, isn't it true, Mr. Aylaian, that on such and such July, whatever date, you busted down Ms. Fitzsimmons' door, went in and, stole things and et cetera?
Yes.
Okay, we intend to ask that. And that's, again, understanding that some of this depends on what he says during direct, and I totally get that.
Yes.
But just from a 10,000-foot view, how is it relevant?
So he's getting special treatment from the government, Your Honor, and he's been coddled and protected by the government from before the service of this order. There's all sorts, and then talk about opening doors.
But why if you're using your theory where he's this background witness, why would the Commonwealth be motivated to do that? And when I say the Commonwealth, the Essex District Attorney's Office be motivated to give him special treatment?
He's in with the right people, Your Honor. We would be able to prove that he's in with the right people. I don't want to give you too much, but I hope you're satisfied with the direction that would go at this point. And he's in with the right people. They knew this was coming. Ms. Fitzsimmons was at the police station the morning of this event, being treated fine, brought the baby to the police station, took a CPR class to refresh for her upcoming appearance on duty schedule. She was treated wonderfully. She saw her friends. She did the training. She passed the training. She had the baby there. People are taking pictures with her. At the time, police administrative officials knew what Justin was doing that day. They knew he was going to do this.
Oh.
We have information, Your Honor, that when one of the gentlemen in the department said, "Oh wait, we got to give Kelsey her radio for July 4th." One of the administrative people said, "Oh no, just hold off on that. You don't know everything that's going on right now."
They were on notice that this was happening. She's one of their own, and they're not protecting her. They're protecting him. And Bradl is now being forced to say this in open court. He shouldn't have to give up all his trial strategy right now, but wow, that's new information, because that hasn't been in any of the papers. We knew that Kelsey went to the station to do the CPR class with the baby, and there's probably surveillance video of that, but we don't know that one of the officers said, "Oh, you got to give Kelsey back her radio because she's coming back on the 4th." And they were like, "No, don't give it to her because you don't know what's going on." Listen to that again. Really important. And it shows that Justin was getting special treatment even before the shooting. That is so important. Here we go.
Appearance on duty schedule. She was treated wonderfully. She saw her friends. She did the training. She passed the training. She had the baby there. People are taking pictures with her. At the time, police administrative officials knew what Justin was doing that day. They knew he was going to do this. We have information, Your Honor, that when one of the gentlemen in the department said, "Oh wait, we got to give Kelsey her radio for July 4th." One of the administrative people said, "Oh no, just hold off on that. You don't know everything that's going on right now." They knew they were conspiring, to use the appropriate word. They were conspiring with Aylaian before this service.
Oh, wow.
For this whole thing. And there's an entirely other.
They were conspiring. Oh, I thought
With
you said-
Aylaian too.
I thought you said Aylaian.
Yeah, I'm sorry, with Justin Aylaian. They were conspiring with him that he was going to go get this order. He was going to communicate with them. They're going to serve this order. And, not to put too fine a point on it, but there were many people in that department that didn't want Ms. Fitzsimmons to go back to work. And this served the police department's ends as well, to blow her up by serving this order in a certain way. So you see where I'm going? There's a lot of doors here, Judge. There's a lot of doors.
The doors are easy from my perspective, because it's about the rules of invisibility of evidence. So, it seems to me that, again, the narrow issue here is whether you get to cross Mr. Aylaian on the fact that these facts related to his alleged breaking and entering, and from my perspective, it would only be relevant when you say special treatment is if somehow he's changed his story, right? So maybe some of this we'll have to hear his direct, but
We don't know what his story is because he was never interviewed by the North Andover PD. Gubitosi has told us that 100 times. He's never been interviewed. But apparently North Andover PD knew this was happening, knew he was going to court. People are saying, why didn't they just serve her at the police department? That's an interesting question because Justin was probably in court at that time. He hadn't had the order yet. He didn't get the order yet. Wow. Just wow. I wonder if Katie Gerke was one of the women or one of the officers who knew, the sergeant that he spoke to on the phone, who gave him permission to break in and even steal the TV. Practically. Makes so much more sense now, right, Allie? So much more sense. Wow, this is big. This is really big. It's all part of the record now.
there would have to be some basis to cross him on it that he's somehow trying to curry favor by changing his story.
I think it also tends to explain the unorthodox manner of service of the order, Your Honor, in the sense that they let him go into the house. Okay, he's an adversarial litigant against the owner of that house. He just got an order against her. Keep her away from me, I'm scared of her. The police let him into her home. So there's all kinds of bias. There's all kinds of special treatment. You know,
I have to say this from my perspective again, that reading or listening, reading the transcripts of these calls that Mr. Aylaian was making to the North Andover Police Department, to say that he was in with the right people, maybe he was on one date, but he was pretty pissed off on the date he was calling, and why?
because he wasn't used to getting this special treatment he had always gotten. And
because he was mad that he was going to escalate it because they wouldn't send a detail for him. And he didn't want to pay for it. That's why he got mad at them, because he's used to getting everything he wants, like a spoiled baby. We have a pacifier emoji for members. Perfect in this situation.
He was pretty pissed off on the date he was calling, and why?
because he wasn't used to getting this special treatment he had always gotten. And it fits the story entirely.
Because during those calls, he's saying that repeatedly that he's going to take it to a higher level. Meaning, I think somebody even asked him, "What do you mean by that?" And he said, "Talking to the chief or something." And how he was complaining that the North Andover police failed to protect him. All right, so I'm not sure when we hear from the Commonwealth. I'm not sure.
A lot of that is just the tip of the iceberg, Your Honor.
I'm not sure that I can rule on this right now. You can tell what my present thinking is. Sure.
He's telling us everything. This is just the tip of the iceberg. Gubitosi stands up, puts his hand on his hip, and he's ready to go. He's ready to fight. Let's see what he's got to say. Let's see if he uses any air quotes.
You can tell what my present thinking is.
Sure, and I agree with that. I agree. He made a statement. His testimony is going to be unless the defendant opens the door, very limited as to the presentation I made a little earlier. If his testimony changes significantly because of that, then it may open up to something different. But having said that, the Commonwealth decided not to prosecute. We're not promising anything. We decided not to prosecute for a specific reason because we believe there isn't a basis to do that, a good faith basis to do that. I can't.
That's right. Justin said he also was going to go to the media. That's right. And he did. He did an interview on Friday. He wouldn't let anybody record it, though. They don't think there's a crime, even though they haven't investigated it. This is, I've never seen anything like this.
Because we believe there isn't a basis to do that, a good faith basis to do that. I can't reiterate that enough, but having said that, what does any of this have to do as to what happened in the room up there? Because if counsel is up here 1 minute saying it should be very narrow, very short case about what happened in that room between Patrick Noonan and the defendant, and then all of a sudden wants to litigate a different case about the corruption of the North Andover Police Department, Mr. Aylaian's favorable treatment. Well, you can't have it both ways. It's either one or the other. And so that's what I'm a little nervous about now, is that, okay, we start this trial one way, and the representations have been made, and now we're taking it to a different place. And that's why the Commonwealth has filed that motion previously.
Okay, so here's the thing. I think where I come out is I have to defer ruling until I hear the direct, or if the Commonwealth were to otherwise open the door. So what I would say is just come to sidebar before you ask those questions, and because I don't, generally speaking, I express my view of it, but it wouldn't be fair of me to Ms. Simmons to completely preclude it without hearing the director or any of the case. So that's my ruling. It will be deferred until. Sure. Yeah, sure.
Can I just say, just in response to what my brother said, I was actually going to use that against him, that they can't have it both ways. If you're going to call the witness, I get to cross-examine him.
I want to use that's why I tried to start the hearing with the agreement that I saw. That is that Mr. Kubatosi saying it was a simple case, Mr. Bradl saying the narrow issue here is it's a simple case, and I want to hold both sides to it. So,
I agree, and I just have a concern about opening doors, and I agree that it should be a simple case. I hope it's going to be a simple case. It should be a simple case. Judge, we're even thinking about making it simpler, and I know we still have to do with all this jury stuff. We talked about a possible bench trial. I don't know
there
yet.
it is.
I'm just saying,
There it is. A possible bench trial. There it is. Let the judge decide. I've been saying this for a while. It'll be a game time decision, but this case they might not have to pick a jury, which will shorten the time frame of this case. That way the trial actually would start on the 23rd. We've watched a lot of bench trials together. Well, at least Penny McGee. And in that case, Judge Cannoni ruled from the bench same day. She didn't have to take it under advisement to come to a verdict. Same day, didn't even take a timeout. She didn't have grave concerns. She ruled from the bench and acquitted Penny McGee. And I think once you get a jury involved here, there's too many feelings. And everyone in Massachusetts says that this judge is amazing, Judge Karp. And he's going to be able to separate his feelings from the law. And he will be the finder of fact if they do go with the bench trial. I don't know that a jury is the way to go on this. Interesting. Okay. But he just said it. I've been saying that all along, haven't I? Stick with me, kids. All right, here you go. He's going to say it again.
Doors, and I agree that it should be a simple case. I hope it's going to be a simple case. It should be a simple case. Judge, we're even thinking about making it simpler. And, I know we still have to do with all this jury stuff. We talked about a possible bench trial. I don't know yet. I'm just saying, everything's on the table still. But, if they're going to call too many witnesses, I got to cross-examine too many witnesses. So, it depends on where they're going to go with him. And, he's going to have his comeuppance in family court. And I don't think I really want to get into it too much here. And if the Commonwealth wants to call him, it's going to happen to the extent you are less. Thank you.
Okay, all right. So I'm going to, on paper 65, I'm going to defer ruling until trial, really until after Mr. Aylaian testifies, and the defense should come to sidebar before asking questions related to that. Let me ask on something that Mr. Bradl just that I wanted to ask, but let's just march. I think we have one more motion. Commonwealth's motion to admit prior good acts. Yes.
Again, I think this would come up more in redirect than in direct of Patrick Noonan. So I would just ask to alert the court that this exists, and if we feel it becomes relevant, we'll decide our prior to redirect.
Okay, so I'll need to defer on that as well.
It's the first time I've seen Kelsey smile.
And let's just talk just generally.
I like to pause it when I talk because I don't want to talk over the stream. Oh, that's a great freeze frame. The first time I've seen Kelsey smile, I think, in a very long time, if ever. She's been going through this since June 30th. Spent 103 days in jail in Chicopee Women's Prison and 53 days in the hospital. Hasn't seen her baby since June 30th.
On that as well. And let's just talk just generally. Do you folks, are there any exhibits that you folks think are going to be the subject of strenuous objections in litigation? And if there are, if you could just, let's just get out in front of them. All right. Sorry, something that Mr. Bradl just raised. I wanted to follow up on it. I just can't recall it. We'll come to it. All right, so what that leaves is paper 73, which is that was filed this morning and the motion to modify the pre-trial conditions.
This is a motion to modify her bail conditions, allowing her to leave the house,
All right, so
get her own apartment, etc.
Paper 73, defendants request for change of address. So let's just make sure that we're on the same page, Mr. Bradl. And that is that you're seeking, there is an order in place now that the defendant reside at a particular address in the fluid.
Yes, sir.
With Lauren and William Page. So you're seeking what?
So Judge,
Yeah.
can we put a sidebar on some of these issues, Judge?
Sure, absolutely. And if we're gonna do that, Ms. Fitzsimmons is gonna come up as well.
Thank you very much.
Thank you. Sure.
Hate that sleep machine. All right, this was 11:45. We're a little bit behind, so we've got room to move here. Focusing on the clock. We can watch the hands of time go by.
Mr. Bradl. So, Mr. Bradl, well, let me just go back just because we were at a sidebar. The Commonwealth objects. This would mean changing the condition to basically two conditions. One is to reside at a particular location in the fluid, and second, to reside with Mr. and Mrs. Page. As far as I can see, those are the two conditions that this would impact. And Commonwealth objects to both. Does the Commonwealth object to both, or to one, or to all both?
Well, there was a long hearing and a long history to this case. And one of the conditions that the defendant was placed under was that she would specifically live, I don't care what house it is, but with her family, with her mother and her stepfather. There was a colloquy with her mom that she would take custody of her, and that she would oversee what she was doing, and that she would report to probation if there were any problems. Now she's asking to live on her own which I think is a marked change to what we've been doing for the past few months. She, in her affidavit, it's basically.
Well, so in fairness, all I wanted was a yes or no. So no, that's fine. Because I want to give Mr. Bradl an opportunity to argue this motion before you. I just wanted to make sure that there is, so it seems like you oppose both, or is it more the supervisory role of the parents?
Well, which resident, if they could move the entire, the family to another house, I don't care about that.
Okay.
You know, as long as probation is fine with it.
So, Mr. Bradl, I'll hear you.
Yes, Your Honor. Thank you very much. So, Your Honor, you know, Ms. Fitzsimmons is a 28-year-old adult. She had this order at a different time in the case. And, you know, I'm not going to get into too much, okay, but this order was entered in very suspect circumstances. And I know what you're going to say, Judge, I'm sorry.
No, it's just not helpful because, but let me ask, Commonwealth, are you objecting to me hearing this motion?
Well, I don't think there's any changed circumstances, so I am in that regard.
Okay.
So.
But the concept of me ruling on the motion in the sense of whether there's changed circumstances, you folks don't object to that?
No.
Okay. All right, go ahead.
So Judge, she and there's actually another aspect to this that we're asking too that kind of go hand in hand.
Sure.
And that is that we're asking also, I'm asking you to lift the restriction from the Superior Court, something I've never seen, where the Superior Court justice said that she can't go to family court and do anything. It doesn't matter what family court says about custody or visitation. The experts that do this, that's their core function.
Where does the order say
The
that?
order here is that she has to stay away from the child and that she, regardless of any probate court orders. I can't point it to you this very second, but it is in writing in one of,
No, I want to
yeah,
it's here.
okay.
I
So,
want to make sure that we're on the same starting point.
Right.
So we have a written motion at paper 73 for Jess
Yes.
after the change of those other two.
right,
Orally, you're moving to vacate the order, so much of the order that, let me see, have no contact, direct or indirect with own child.
and only to the extent to say, subject to deferring to probate court. So subject to probate court orders, that's all.
Well, there's also a restraining order out there that has never been challenged at this point, so like.
But if, in other words, if I were to vacate.
It hasn't been challenged because she has this criminal trial pending. You dumbass. And he does have tiny hands, like the lady on Saturday Night Live. He's got the little tiny hands.
That and make it, so, you know, she's already, Ms. Fitzsimmons is already ordered to obey all orders, court orders.
I would leave that up to the board.
Okay.
As far as, I'd leave that to your discretion.
Okay, all right, so that's easy. I'm going to vacate so much of the pretrial conditions that requires no contact, indirect or direct with the child.
Oh,
Again,
look at Kelsey's face. That's a huge win. That's a huge win. He is taking Judge McCarthy Neyman's order and putting it in the shredder. He just put it in the shredder. Kristen Wiig, yes, with the tiny hands. Look at her face. He's vacating that part of McCarthy Neyman's order that says she can have no contact with the baby. But remember, there is a stipulation in the family court where they agreed she'd have no contact with the baby. But now she can go back into family court. And now she can make the application to see her baby. And how much stronger is her application going to be now that she's got all the video of just in it for the money, smoking the reefer, breaking into the house. Who knows? Maybe it's crack. I don't know. Breaking into the house, destroying her property, stealing her money, stealing her passport. All of that is going to work in her favor in the probate court. And that is the proper venue for all of that. I'm going to replay it. Don't worry. You know I do. You know me. Oh, I don't have my tissues with me, but I wish I did. This is what she has been fighting for all along. Right. The Commonwealth never fought the conditions with Neyman, but now they're against it all. Right. This went all the way up to the SJC, these bail conditions. All right, let's listen to that again. He's vacating the part of the order that McCarthy Neyman said she was to have no contact with her child. This is a huge win. Everyone, please donate to Kelsey if you can. The link is below the video. Replay.
Of the pre-trial. Okay.
Sorry, Mr. I leave that to your discretion.
Okay, all right, so that's easy. I'm going to vacate so much of the pretrial conditions that requires no contact, indirect or direct with the child. And again, only because since the passage of a long time,
Yes.
we now know, because the Commonwealth provided dockets, that there is ongoing, at least a case has been opened related to the well-being of the child in the probate and family court. They're the experts. But I want to say that all that this initially did when it was entered was essentially ordering her to comply with the restraining order, because the restraining order had, it wasn't Judge McCarthy, it was the probate court judge that had granted.
The restraining
Right, okay. So I will vacate that.
Thank you.
And
And I could just tell you, just so you know, Judge, the motion for temporary orders has been filed, and the hearing on that is 4-2. So it's probably after this trial.
can I ask something more out of intellectual curiosity? The Commonwealth in your motion provided the docket.
I'm sorry, what? There's a judge in the Commonwealth with intellectual curiosity? Color me shocked. It strains credulity. This judge has intellectual curiosity. What?
So it's probably after this trial.
Can I ask something more out of intellectual curiosity? The Commonwealth in your motion provided the docket entries of the custody parenting case, but it didn't mention that those docket entries didn't mention the restraining order at all. Is that because it was taken out under a different docket number?
Correct, Your Honor.
Okay.
It's a separate case. I actually represent Ms. Fitzsimmons on the restraining order in family court, and my colleague, Ms. Hess, represents
Okay.
her
But
for the
it's a
custody.
completely different docket number. That's why I wasn't seeing it on the document. All right, so.
And that date, Judge, just so you know, 4/14 is for the restraining order itself.
All right, so I'm going to vacate that, and Mr. Boyd, just remind me, I need to, so you've docketed the orders, the order of pretrial conditions 74 and this GPS at 75. So I'll need to just change those, but let me wait until I decide the other issue. Let me hear you.
I told you Tiny Jesus would work. I told you Tiny Jesus would work today. This judge dug into the docket. He did some intellectual curiosity type stuff. He dug into the docket. He said, why can't I find the restraining order here? Mastat says Judge Karp is amazing. Can you see why they might want to go with the bench trial here? Can you see why? It's a huge ruling. Huge. Tiny Jesus is here.
Thank you, Judge. So Ms. Fitzsimmons is preparing to be able to offer the family court a viable, good situation for whatever custody visitation she can get. And she needs to do that in advance of the 4-2 and the 4/14 hearings, so that she can go to family court and say, you know, I now have a home, I have a good, you know, that's the first question the family court judge is going to say. Well, if I give you something, Ms. Fitzsimmons, where are you going to be? Where's the baby? And we want her to be able to say, not that I'm at my family home in my high school bedroom. I want to be able, for her to be able to say, I have a wonderful townhouse, plenty of room, fenced in yard, great situation, and I'm ready to go, Your Honor. And you know, we'll also proffer Dr. Zeisel's report that we have.
She needs to be able to nest, Your Honor. She needs to nest before these hearings on the 2nd and the 14th of April so she can, because she's been through this before. When they were trying to get her out, released to the custody of her parents. She's got to have it set up and ready to go. She's got to nest.
Here for you that this is a good thing for her, that this is something that is consistent with her very bright future, that's something that is appropriate. You know, this was a 4-month-old child who's now a year-old child, over a year old, and that this needs to happen. for so many reasons, Your Honor, that I won't get into, but she needs to have a situation that's ready. And I think we have expert clinical evidence to show that in the present circumstance, she's ready for that. And that we were asking the court to get on that bus and help her in this sense so that she's ready when this is over with. She's ready. She's in the best possible position she can be in to go to probate court just a week or two later with this in place. If it's not in place, God knows it's a nightmare scenario, Your Honor, because I'm sure you know the probate court dates are like, you know, they'll without batting an eye, they'll set up an August 8th, you know, and Ms. Fitzsimmons will be sitting here, you know, that's a good point. So it's a very difficult
he knows.
We're just trying to get all of our ducks in a row as best.
Judge laughed and said, yeah, August of what year? That's how long the dates are in between family court cases. Oh, if you're ahead, please don't spoil it, but I think he might allow it. I hope.
We can, and this would be something that I don't think asks too much. And, you know, she's agreeing, and you see in her letter and in my motion that she's saying, I don't want my lawyers to disturb any of this other stuff, you know, about house arrest and SCRAM and, you know, the 2-hour notice, which we appreciate very much, to come see us. She doesn't want to disturb anything else. She just wants to change her address and live like a grown-up.
So can I ask something, Mr. Bradl, then? So there was much litigation prior to my involvement related to the alcohol testing, urine testing. And why isn't alcohol use mentioned at all in Dr. Zeisel's report? I think in either of his reports.
Sherry said that's Dr. Zeisel sitting beside Kelsey's dad. I don't know for sure, but if you know for sure, that's great. But when we saw him testify in the last trial in Lucy Medina, the camera was pretty far away. I didn't get a good look at Dr. Zeisel, so I'm very happy that he's there to support her.
So, because it's something that, and I'll give you my real answer.
That's all I want.
It's something that was imposed on her to stick it to her, to punish her, Your Honor. There's no alcohol whatsoever in this case. There's no pattern of anything. It's a total red herring, and it never should have happened. And I am furious about it. It is absolutely beyond the pale that she was tortured with that SCRAM device, Your Honor, and I'm furious about it, so I'm sorry, but talk about, you know, you got me on that one. I'm furious about it. It's baseless, is my answer, sorry.
So leaving aside your argument about whether it's baseless or not, I mean, I can tell you that I read all of the impounded documents that the judge relied on in fashioning the order, and alcohol was mentioned by Ms. Fitzsimmons' own friends that were at that. So now,
Right.
let me say this.
At one party.
So my only point is that it's. So your position basically, actually you answered it. You're basically Dr. Zeisel didn't weigh in on it because he presumably doesn't think it's an issue.
And he's here, so like I said, if you want to put him under oath and hear from him, I'm sure Dr. Zeisel will echo everything I'm saying about how there's no evidence, nothing's evident about any alcohol issue in terms of, you know, at a bachelorette party, a week or a few days earlier, whatever, fine. But as a basis for long-term, you know, monitoring is outrageous to me. And the only other thing in the record, Judge, talk about a reach, 2018 in like Myrtle Beach or something.
Yeah.
And that,
this isn't helpful.
And that was expunged.
I realize that I kind of opened the door.
I'm sorry. He's here, Judge. If you want to hear from him, you can get some more evidence on it. You know, the alcohol issue really is not.
Thank you.
I've been well, but you?
I've been excellent.
That's great.
I should say one last point, Judge, I think you missed. Ms. Fitzsimmons was breastfeeding at this time. She's not drinking. Doesn't have an alcohol problem. She's raising her baby. She's a wonderful mom. And this whole thing is infuriating. I'm sorry.
No, there's nothing to be sorry about, Mr.
He's
Bradl.
so
You're
emotional.
an advocate, and a good
He's so emotional. He's just like us. I think he was about to cry too. I want to hear that again. He's so outraged by this. He's a dad. He gets it. He's a fierce advocate. This is what you call zealous representation. This is the kind of lawyer that you want fighting for you because he is so passionate about the Constitution. I have pinned Kelsey's Give Send Go in the chat. If you have any dollars to spare, please put them there instead of giving them to me. I would appreciate that so much. Watch.
How are you doing? I've been well, how about you?
I've been excellent.
That's great.
I should say one last point, Judge, I think you missed. Ms. Fitzsimmons was breastfeeding at this time. She's not drinking. She's not doesn't have an alcohol problem. She's raising her baby. She's a wonderful mom. And this whole thing is infuriating. I'm sorry.
No, there's nothing to be sorry about, Mr. Bradl. You're an advocate, and a good advocate for your client, and the judge asked you what you answered, and when the judge asked you, then you didn't want to hear the answer. So, I get it. But the point is really, in all seriousness, the point is you're not seeking to change the SCRAM. Right? And so, can you just tell me, how does the SCRAM work? Is it random or is it? Probation. Hi, how are you?
Good morning, Your Honor. Well, good afternoon.
Yeah, come on up. And you are again?
Alexander Hunt for probation.
I'm sorry?
Alexander Hunt.
Hi, okay. And do you want to swear her?
Would you raise your right hand? You solemnly
He's got everybody there today. He's ready. He's got Zizelle. He's got probation there. He's got everybody there. I love a reasonable judge too, Wildflower.
swear to make true answers to such questions put to you by the court or upon its directions, so help you God.
Thank you.
Thank you.
I'm sorry, I don't think we've met before. Before this morning at the other hearing. Officer Hunt, are you supervising Ms. Fitzsimmons?
I'm not, Your Honor. It's P.O. Scrunchy in Salem.
Who is it?
P.O. Scrunchy.
P.O.
How do you
Scrunch.
spell that?
SCRENCI.
Scrunchy has entered the chat.
All right, another officer that I'm not familiar with. So what is the report back? Has she been in compliance?
She has, Your Honor. She was 7 minutes late to curfew on March 10th, but she had informed Elmo ahead of time, and points show that she was stuck in traffic coming back from an attorney's appointment. She also missed 2 SCRAM tests, but then passed the immediate on-demand test. So she's passed all her SCRAM tests.
Okay.
So other than those minor incidences, she's been in full compliance.
And the SCRAM, how does it work, or how is it working in this case? Are they random?
They are random.
Okay, so what happens? Does something go off on the device or something?
That's correct, Your Honor. A noise alerts her that a test needs to be taken, and then she has to take the test.
Okay, is that something that, again, this is more intellectual curiosity, because I haven't
He has it.
really had the opportunity to learn about how exactly the SCRAM device works, but I think it's important for me to know because it's one of the more significant parts of the pre-proposition work. But what happens for the notification? Is it the GPS monitoring bracelet that goes off that tells?
Those are separate, Your Honor,
They're
but
separate.
Elmo supervises both of those.
Okay, so what happens? How does Ms. Fitzsimmons know that it's time to do a SCRAM test?
It alerts her, a noise goes off.
So, and what is this device? The device is a breathalyzer or something?
Essentially, yes, Your Honor. There's a straw that she has to blow into. It takes her picture so it knows it's her. And that's how, and then via like Wi-Fi essentially.
So does that mean that she has to have that with her?
Look at Courtney. Courtney, excellent manicure. Manicure on point today. She's got the SCRAM device right there in front of her on the defense bench, on the defense table, in case the judge wants to see it. And he's got intellectual curiosity. He wants to know how it works. Here we go.
When,
At all times.
okay, so when she leaves to go to doctor's appointments?
Yeah, so Judge, I got it right here. It leaves from 7 a.m. to 11 p.m. all the time, and she blows into it, and it took her months to be able to blow into it without a lot of pain, and she can do it now because her rib is healing up. Her rib was blown apart in this shooting.
Blown apart.
And she can breathe now, and she can do it. and it gets on her from 7 in the morning till 11 at night. And it also has a GPS component to it as well. So she's on double GPS.
Roughly, I know it's random, how many times a week do you know that it asks? Is there?
I'm not positive of Ms. Fitzsimmons, but I believe probably does around 50 tests every 2 weeks. I believe she has many random tests a day as ordered.
Judge, I think it's for Ms. Fitzsimmons, I think it's about 4 times a day it goes on.
And pass with flying colors as far as we.
Correct, Your Honor.
Good, that's good. All right, Mr. Bradl, is there anything else on, I'm sorry, anything else on Officer Hunt that I should know about her performance on pretrial conditions?
No, Your Honor, she's been in full compliance and in communication with probation.
All right.
So she's been a great probation judge. I appreciate you inquiring about that on your own. And, you know, it's just a step in the right direction for her. It's not a lot to ask. It's something that I know based on my interactions with her over the last 9-10 months, that, you know, she's very motivated to not do anything in contravention of the court.
So what is, actually, I'm not going to ask you this because I know what the answer is. Mr. Gubitosi or Ms. Moriarty, what was the purpose of ordering Ms. Fitzsimmons to be in the custody?
Yeah, tell us.
It doesn't say custody, to reside with Lauren and William Page. But
Karen Reed was allowed to live on her own, remember? Karen Reed was charged with second-degree murder. She didn't even have to wear an ankle monitor. She had no alcohol testing, and her alleged offense, allegedly, did involve alcohol. Kelsey's didn't. Why does a 28-year-old woman need to be released to the custody of her parents? Great question. Let's see what Gubitosi says. I've pinned Kelsey's fun in the chat. Oh, I told you that already.
Well, I can't speak for Judge McCarthy, but I was there. This is not something that I agreed to, I encouraged or anything like that.
Oh.
It sounded like.
No objection?
That, because of the situation in its entirety, including a statement from her high school friend that she's had an alcohol problem and an aggression problem since then.
Her high school friend.
That the judge thought it was appropriate for the mother to monitor her. So she made sure
Her high school friend did not come in and testify in front of Judge McCarthy Neyman, correct? Her high school friend may have submitted an affidavit to the probate court, but how did the judge get that? Who leaked that to the judge? The judge was looking at papers that she was not submitted, and Commonwealth didn't look at him with his little tiny finger pointing. And pacifier, please. Boss baby, please. You didn't oppose it ever, but you're going to oppose it now? My freeze game is on point tonight. Her high school friend. With friends like that, you don't need enemies. Her friend did not come in to testify in front of McCarthy Neyman. The hell are you talking about, sir? Oh, look at that. That's a great freeze game too. With Kelsey, with Courtney's face. Hold on. I gotta take this down so I can use it later. Kristen Wig hands. All right, here we go.
an aggression problem since the situation in its entirety, including the statement from her high school friend that she's had an alcohol problem and an aggression problem since then.
I saw it.
That the judge thought it was appropriate for the mother to monitor her. So she made sure she does everything, including making sure there's no weapons, no dangerous weapons, nothing in the house that would be considered dangerous.
Courtney's like,
so that is what Lauren Page, the mother, had sworn that she would do. And I think that answers your question as best as I can answer it.
Okay, and tell me about your objection.
My objection is, we're all glad she's doing well, but why are we going to mess with it at this point? We have a trial in 10 days, which is going to be a very stressful time in her life, I'm sure, that we're coming upon. There have been no change in circumstances to suggest that, no real change in circumstances.
now all of a sudden you're concerned about her stress levels, sir? Counselor, my brother, now all of a sudden you're concerned about her stress level? She's also got family court hearings and custody hearings coming up, and she needs to nest.
She suggest that this is an appropriate reason to change anything or a time to change anything. I think all that could happen here is we mess something up and it messes with the trial date. Or she hurts herself or she hurts someone else. That's what this is about. These conditions were put in place for a reason. I would suggest they were ultimately fair. I just don't understand why, if in her letter to the court,
Did she sign that?
Yeah.
her primary reason for this request is in preparation for my investigation of my child. We're talking 2 weeks. 2 weeks from the time of today to basically, we could be finished if it's a streamlined trial. If it's not broke, let's not fix it.
Well, but from her perspective, it is broken. That's what she
Sure. In my perspective, and from the unbiased really look at this, it's not broke. She's doing everything the court has asked her to do, which she should be doing. And so, what's the changed circumstances at this point?
She needs to nest.
Change circumstances.
I point to Dr. Zeisel's report, her letter, the passage of time, the fact that we're in a trial posture, and sort of maybe why don't we analogize it to, when someone asks you to remand a guy from Pittsfield to Essex County House, it's like counsel for the Commonwealth is answering my own question, which is, it's a stressful time because she's in a difficult situation and it's hard for her to prepare. If she has her own home, it's much easier. She can come and go. She has the whole place. She can focus on other things when she wants. It's just I don't want to make too much of it, Judge. She's just going to go to an appropriate home, and it helps her in her family court efforts. That like I said, I don't want to get pushed off months and months if we're not ready on that occasion. So
I'm sorry, but
I'm alluding to what I mentioned earlier, Your Honor, about how on the 2nd and the 14th of April, we're going to be in family court. And I want to be able to say that she's been in her house for a couple of weeks. She has a great situation. She's been setting it up. And, it'll just take a lot of the, it'll uncap the tea kettle and a lot of steam will escape here if she can just kind of be in her own place.
right, that would be grounds that would support my revising or modifying those two conditions. But I can say that I think the teachings of the SJC's cases under 50 a day often are that the passage of time can be a changed circumstance.
Good, go with that.
Here, there is arguably a changed circumstance because Dr. Zeisel has said that her mental health has improved significantly, because my memory is that in the first report that Dr. Zeisel wrote that's in the file that's impounded, he did imply or mention that she didn't contest that she had been suffering from mental health concerns at the time.
Yes.
And Ian directly after. So I do see, I guess the long story short is I do see sufficient change in circumstances. The question is whether the supervision by her parents is something that I would change on this record. And so does Ms. Fitzsimmons have an address in mind?
Yes, Judge, it's all set, even the lease is signed.
When would she move?
As soon as you're ready, Judge. She has custody of the place. Whatever would work she's ready to go.
And
it's in Essex County, and certainly will give you the address, obviously.
right, and she's amenable to having probation inspect the place prior to her move. Yes.
Yeah. Oh, absolutely. I think that's.
And how about if I were to order visits to
No objection.
to ensure compliance with the no weapons and et cetera.
No objection.
Oh, I thought he meant visits with the child. He meant visits from like probation coming to her house and just checking on her. Fine, whatever it takes. Come on, let's do it.
So sorry, Officer Hunt again, come back up. So can you tell me, if I were to order some kind of a visit by probation before the defendant were to move into the location to make sure that it is a place that, at least from what is observed, that doesn't have any weapons, to see what exactly were. No weapons brought into home, so weapons being pretty broad. Is that something that the probation department can do?
Absolutely, Your Honor.
And how about, I know that home visits happen all the time when someone is on post-trial probation. Is it something that you folks see occasionally, at least on pre-trial?
I'm aware of one case we've had where we have done it, so I believe it's possible, but I would like to double check with the supervisor. As for the home visit, that could be done, the initial home visit to check, we could do that by the end.
Is Officer Scrunchy available for at least maybe even for you to communicate with about that aspect?
Yeah, I can contact her right now.
So it seems to me that, and again, I don't want to go back and forth on this. I read all of what the original judge had before her, and all of these orders were well supported. They were orders that I would have issued at the time. They're orders that a single justice affirmed. They're orders that the SJC affirmed. I don't want to relitigate that, but.
He's trying not to throw Judge McCarthy Neyman under the bus without throwing her under the bus. Okay, let's see what happens.
I also believe that there's sufficient grounds to consider allowing the move and allowing the termination of the supervision, I guess, or the residing with the parents, so long as the probation department could monitor, and it would be by surprise monitoring. So, Officer Hunt, I don't know if you heard that. So I want these visits to be a surprise.
That's no problem, Your Honor. I also just spoke with my supervisor, and she said as long as it's a court order.
Either side want to be heard any further?
Judge, I just should say that her PO is aware of this request and it's been discussed. And, I shouldn't say that she agrees with it. I just said that she's fine with it in the sense of whatever the court orders, she's happy to implement.
Anything else, Kamala? Okay. I'm going to allow the change.
He's allowing it.
Subject to an inspection by the probation department prior to the move, Ms. Fitzsimmons' move being physical move into the new place. And the inspection will be for weapons and also alcohol.
She's allowed to move out into her own place like an adult by herself with no supervision. Tiny Jesus was here. Tiny Jesus worked. As long as probation can make random visits to make sure she's got no weapons and who knows what else. I don't even care about the rest of it, but she got 2 big wins today. He vacated Judge McCarthy Neyman's condition that she had have no contact with her baby so she can go fight that fight in family court. And he's allowing her to nest and move into her own damn apartment. Right away, I think, right away, because probation's there, everybody's there, Zizella is there, they're all there. Look at her face. What a day. I didn't know when I was so cranky this morning and tired that this was going to be a good day, because it usually is not a good day for Kelsey. So Tiny Jesus worked. Take it from the top. Look at her face. Oh my God. Thank you guys for caring about this case and for donating to her fund. It's over $100,000. When I first started covering this case, it was like $1,000 or $1,800. You guys, there is power in numbers.
I'm going to allow the change, subject to an inspection by the probation department
prior to the move, Ms. Fitzsimmons moving, physical move into the new place. And the inspection will be for weapons and also alcohol. You may as well look for that.
I don't care.
And it will be subject to inspections, random inspections by the probation department. I think what it may make sense at this point is for me, which would also mean that the GPS supervision conditions would need to be changed. I think it makes sense, Officer Hunt and counsel, for me to just issue a new order, and rather than write on this, I would carry over all of the orders. No, you know what? I don't think it's necessary. Do you have do you want to have the sidebar on the address? Or is it something that you can provide?
No, we don't want
I just
Justin to
provided
know.
probation judgment.
Yeah, but I need to keep sure. Everybody come on over to sidebar.
For the record, look how happy. That's her dad in the purple tie. Steve. Yeah. It's a security expert. He's been there the whole time. He's been at every hearing. As have her mom and stepdad, I believe, and her family has been very supportive of her. What an amazing day. We're a little bit behind, so thank you for not spoiling it if you were ahead. Let's fast forward and move a little bit into the closer to real time. Bradl's happy.
All right, so I am going to allow that modification for the reasons that I've already described, both open court and at sidebar. I need to just write it up. We'll impound the new address. I'd ask all counsel, as I said at sidebar, to continue to keep in mind that we want our jury pool to be as made up of as indifferent of a group of folks as we can. That
was Turtleboy walking in right as the judge was speaking. I'm going to rewind it. Everyone waved to hear Aiden. He walked right in. The address will be impounded. Good. And he's saying, guide your actions accordingly on the pretrial publicity, because we want an untainted jury. I don't think they're going to go with the jury. I think they're going to go with the bench trial, but come to your screen if you want to see Aiden walking in. Guide your actions accordingly. It's all out there already. It's out. Everything's out there. Everything that everyone needed to know is out there now.
We want our jury pool to be as made up of as indifferent of a group of folks as we can. That's what my expectation is going forward. All right, so I need to change that. Anything else, folks?
I filed another final certificate of compliance, so I'm expecting any moment council's reciprocal discovery.
So, when you say, is that something? So, is it something that I need to weigh in on, or are you just making a record?
Just making a record.
I'm sorry, I missed it, Judge.
Mr. Robertosi reported that he filed a final certificate of compliance under Rule 14, and that he's hopeful that.
I think we're there. There's a couple little things, but I'm not going to make any sure.
All right,
We can
so.
work on it. Thank you.
Like we got what we wanted today.
But also, I need, and I appreciate the sending of the joint witness / prominent names list. But there's a bunch of names on there that don't have towns or cities associated with them.
Yes, as counsel said at sidebar, there's a safety concern in this case based on things that have happened. So I will get those to the court before the trial.
All right. So, but how do we handle? I want to provide enough information for the potential jurors to look at that list and say whether they know a person or not.
We'll get a town.
Okay.
And then, but are you suggesting that that be impounded?
No.
Okay. So, all right, so the missing, you folks will get, run down the missing cities and towns of the folks that don't have them on that list.
I have them, but I'll supply them to the court.
And Mr. Bradl, given how close we are to the trial, and it behooved me when you said that, something to the effect that there was a couple of little things that perhaps, the bottom line is, are you prepared now to disclose whatever it is that you're required to
Yes.
disclose?
Yes.
And I'd ask you to do that as soon as possible so we can keep the trial on schedule.
Sure.
All right, and let me just see if there's any else. Mr. Wayne. In a perfect world, we reconvene to talk about the juror questionnaire. Which we could. So are you folks, would you folks be available Monday afternoon? By then I disseminate the drafted juror questionnaire. That's all that we would go over. And you, Ian, hold on a second. Ian, you can appear by Zoom if that would be easier for you folks.
So if we're only doing the questionnaire, yes. That's fine.
Available, yes.
All right, so in other words, no surprises from the Commonwealth.
No, I'm not expecting any.
Okay. I can't, we'll all be surprised if there's surprises. All right, so that means I have some work to do. I need to get that out to you. Mr. Roy, you have their email addresses?
Yeah. Did you say 2 o'clock Monday? 2 o'clock.
Whatever Mr. Roy said. So, all right, so I need to, I'm going to step off. I need to write up the change conditions, which I will do if you want to just hold tight.
Thank you.
2 p.m. this Monday is the 8th. All right, so we'll stay in recess and see you then.
All rise.
Kelsey, that's the face of a happy mama. What a great day. Today's a good day to have a great day. It's a good day to have a great day. What a great day. I do not have her Amazon list. Hugs all around. Dr. Zeisel. Kelsey hugging. He's the expert witness, forensic psychologist. Testified for Lucy Medina. Testified in the Turk trial. He is going to be also the expert witness for Lindsay Clancy. Wow. Here comes sunshine. Oh, I love that song. Grateful Dead quotes are always welcome here. Hugging some supporters in the courtroom. Love all the purple in the courtroom. Look at all the support. He's going out. Judge is going out to write up the order. Today's motivational quote. Where did I put it? Somebody remind me. I don't even know where I put it. I think it was Julius Caesar. But we didn't pull the empowerment card for the... Oh, wait. We didn't pull the empowerment card, did we? Let's do that now. Did we already do that? All my days are blending together. Where's Tiny Jesus? Picked him up because he fell on the floor. He's been in my hand the whole time, and he was on my hat for part of the day. Look, there's Aiden. I even was able to balance Tiny Jesus on my hat for a while because I have skills. I have skills. It's not just legal analysis. You can also balance Tiny Jesus on my hat. We need an empowerment card. Let's do it. We all need empowerment. Everyone needed this today. We all needed this today. Here we go. You can waste your life drawing lines, or you can live your life crossing them. Oh, wow. This is a good one. You can waste your life drawing lines, or you can live your life crossing them. There you go. We're still watching the walkout from the courtroom. It's a good one. I have balancing skills, Mitchell. You know I do. For those of you who need a recap, we're going to do that in a moment. I'm just going to fast forward a tiny bit, see if the judge comes back and says anything more on the record. Aiden Carney talking to some people in the courtroom. Kelsey hugging Bradl. That's a great shot right there. Print that for later with Aiden in the background. Hold on. Print that. Print that. Tim Bradl also represents Aiden Carney, as many of you may know. We came, we saw, we conquered. That was the quote today, right? Julius Caesar, we came, we saw, we conquered. And it worked. It worked. I don't know where I put the little piece of paper because I'm all over the place today, but that's right. That was the motivational quote of today. Thanks, Calla Lily. I mean, come on, you guys. We've been talking about this case. We've been screaming about this case since July of 2024. Print that. We came, we saw, we conquered. Thank you, Nancy, for your very generous 100. She said, thank you for all you do. We appreciate you. I appreciate you all so much more than you know. Thank you, Jessica, for your Venmo. Says, thanks for covering Kelsey and Karen Reed. Thank you, Sherry, for your Venmo. Says, didn't realize I was unsubscribed. I can't comment, but PPD is a medical condition of hormonal imbalance. Wait, so does that mean the judge isn't coming back? I think we've seen enough. Let me just see if they come back, because it does go on for a little bit of time here, like 20 more minutes. Oh, wait, they're going to go outside actually and get some footage outside? Wow. Look at NBC 10 getting it done. Okay. All right. We're here for this. They got the cameras set up. I mean, the mics set up outside. So let's see if they got a little presser outside after they came out of court. I mean, they still have their feet up, so maybe they're waiting. We know they have the mics set up. So let's take some comments while we wait to see if they get anything outside the courthouse. Thank you, Betsy, for your Venmo. Says, let's go. It went, Bets. It went today, didn't it? It sure did. It sure did. Thank you, Jessica. Elaine, thank you for your very generous 100. I was going to say husband. On the move over here, but tuned in. Thank you for covering Kelsey. His true colors are coming out. Yeah, but it was a win today. It was a big win, Elaine. As you know, if you were able to listen. And thank you, Betsy, also. What a day. All right, let's see if they come out and do a presser. I'm going to go back. I put most of these up on the screen while they were coming on. Hi, Fairy Raven's late. Don't worry. Go back to the start. It was a great day. It was a great day. Kyle's been watching while cleaning the kitchen. My wife hears yes and asks what happened. Thank God. Thank God. I put most of these up during the stream, but let me thank you all again. Thank you, Quilting Queen, for gifting 5 memberships. Thank you, Gary, for gifting 5 memberships. A lot of new members today. Thank you, Friend of Dog, for gifting 10. You're the greatest. Nicole, who said, watching your streams through all these insane cases is a must for me. I need fellow rage watchers to get me through them. Thank you. Thank you. Teresa said, I didn't know that. Says, thank you. I love you with all my heart, too. Gigi, I'm waiting just in case to say that was AI. Come on, Justin, don't let Gigi down. Gen X, I am. Jen says, having to give her baby to a drug user would definitely affect her mental state. Because she knew all of this. She knew all this when they came to serve her with that order. Gordy's mom said, opinions don't equal facts. Airline employees and first responders fall under the federal guidelines. Marijuana use is not legal for us. It impedes response time and operation of equipment. Exactly. It's dangerous. How dare you? I had to take a call. Did the judge allow Justin's employment files? No, but that is the only thing today that he did not allow. Karen, thank you so very much for your very generous 100 on Cash App. She says, crying happy tears today for Kelsey. Thanks, Melanie. Thank you guys for being interested in this case and blowing this case up. The Cat Harvey said, this judge's opinion on the marijuana ruling is so strangely adamant to me. And then you wondered something else that I'm not going to read out loud, but thank you for your 20, allegedly, in your opinion. Sandra from Canada says, funny how these judges rule from the bench when it's to deny these defense's motions. Listen, he hardly denied anything today, but I think that was when they denied Justin's employment and drug records. Here's the good thing, though, and Bradl hinted at it, and I've been saying this all along. If they do go with the bench trial, the judge knows all of this stuff that the jury wouldn't be able to hear. And so is it going to influence his ruling? It's not supposed to, but he knows that he can't unhear it, right? I think a bench trial would be the way to go here. I really do. Sue said the 209A did not grant Justin the right to obtain his possessions. It should have been amended or a civil order obtained. A list of items or types of items should have been provided. He never should have had unfettered access to her home. And I agree with you. The judge sees all the shenanigans, right? None of this was about custody today, but a lot of the things that came out and all the videos of Justin, et cetera, are going to play well for Kelsey in the custody hearing, which is coming up, I think, on April 2nd. And then another one on the 14th. Gigi, Red Rover, let Noonan come over. Thanks, Gigi, for your 5. Christine Mitchell says the Aylaian has no chance. Thanks, Tracy, for being here for a month. Tracy says, aren't there decisions, harassment complaints against the police chief? Yep, we went over some of the lawsuits. He was probably happy to throw a female officer under the bus. You're talking about the police chief, Gray of North Andover? Judge probably knows all about that too. Under Your Scars says, any use of substances in any job, if there's an incident, is a massive liability. This is ludicrous. I could spit nails. Thank you for your 5 from Canada. Desiderata said that she was bawling. And we love you, Kelsey. Thank you. Bima says, I'm not crying. You're crying. Thank you. Kippy Hippie was having goosebumps and says, I know the pain, Kelsey Fitzsimmons. I know the pain. And Manj, can we get a tiny Jesus emoji? I think I'm going to have to work on that. Thank you. Sherry, told us that was Dr. Zizel. Thanks for pointing that out. Christy said, I know exactly how she's feeling right now. Her heart is just burst out of her chest with joy. Came, I saw, I conquered. That's right. That was our quote. Crazy how prophetic that was, right? Palace says, without you, your knowledge and followers raising awareness, this could have gone a totally different way. Continue to do what you do, including in educating us in our fight for justice. Thank you so much. Thank you so much. To me, I don't know, to me, cases like this are more interesting than Corey Richens. I don't even know her name, but not to say that that's not an important case too, but I'd rather be here. A desire for civil discourse says, a little behind, but 270 events in a few months means more than 1 per day. If that were alcohol, it would tell the story of a problem. Talking about the 270 videos of Justin smoking something. Joanne said, now Justin is the only one living with mommy. What a wonderful day for Kelsey. Positive vibes is voting for a bench trial. Kyle, we read that earlier. Thank you, Mrs. Bouquet, for your super sticker. Shout out to Harrison. If he's with you today. Cupcakes for Justice, gifted 5. Thank you. Thank you. So we're waiting to see if they come out and do a presser because the mics are set up and the judge was out doing his ruling. All right. So the first thing that happened today was a decision on the Rule 17 motion. The defense wanted to get or wants to get Officer Noonan's employment records from not only North Andover PD, but also Lawrence PD. Gubitosi, first thing he said was, Officer Noonan has nothing to hide. He's willing to give them. So that was on consent. They're going to get all of Noonan's records from both police departments. Then they argued for a bit about Justin's records from North Andover Fire Department, about relevance and all kinds of things. That's where the videos came in. And that motion was eventually denied. And there was a lot of talk about whether Justin's going to be called to testify. And Bradl said, I don't even know why they would call him because he's going to open up a lot of doors. And in the end, I believe, and I think it's going to be reduced to writing. In the end, Judge Karp did deny that motion for Justin's employment records from North Andover Fire Department. Yeah, Proctor had nothing to hide either. But then there's more. At one point, Tim Bradl, and I wrote this down, said, prove it up. And maybe we should make that a t-shirt, prove it up. And this was when they were talking about the smoking of marijuana, smoking in the boys' room, smoking in the shed, smoking on video everywhere with a pipe of some sort. The judge denied that motion. He said the requirements of Lampron were not met, but that's okay because I think that was the only loss today. Motion for sequestration of witnesses were granted. The prior bad acts, I think, is reserved for the time of trial if Justin is called. They talked a lot about jury questions and what jury questions are going to be asked, and they're going to talk about that some more as the days go by. The female prosecutor and Gubitosi both called Justin Aylaian. Smoking ain't allowed in school. You know it. All of that stuff will come in family court. All the Justin videos, all the Justin breaking into the house, all the Justin. If he's willing to lie here, is he willing to lie in his custody petition? It's going to be, his credibility is going to be destroyed in the family court, in my opinion. The jury questionnaire is going to be impounded because a lot of documents have been leaking and the judge does not want to taint the jury pool. And I think he's right about that. The judge said that he thinks jury selection in this case will take longer than the actual trial. He said he thought it would take 2 to 3 times longer than the actual trial would. We've learned that each side will get 4 peremptory challenges when it comes to the main jury, and then 1 peremptory each on alternates. It was a pretty long conference. It started at 10. It's 1 o'clock now. And then we learned Officer Noonan's current duty status. Currently, Noonan is on leave. That was new information. I don't think we knew about that. But we did know that he did go AWOL at some point. And when the North Andover PD came to his house to do a wellness check, he told them, allegedly, that he had taken a Flexeril and then he didn't get up for work. And now, for some reason, he's on leave. We don't know why. Bit of justice at long last. Yes. Then we got into the Commonwealth's motion for promises, rewards, and inducements, and that has everything to do with Justin. The prosecution said that's a slippery slope, judge, because this alleged breaking and entering, we don't think he was committing any crimes, and this is, and Bradl even said this is, I don't know why they would even call Justin because it's the potential for this is a mistrial witness, is what he said. This is a mistrial witness. Because the North Andover PD knew exactly what he was doing when he was going to break in. And he said the North Andover PD was conspiring with Justin even before he went to get the order. Because that morning, June 30th, Kelsey was in the police department with her baby doing CPR. Everyone was so friendly to her. And then somebody said, we should give Kelsey back her radio because she's coming back to work on July 4th. And another person who worked there said, no, don't do that because you don't really know what's going on behind the scenes. And so apparently there may have been some conspiring going on with Justin, with the North Andover PD, even before the order was issued. So before the shooting, it's a big problem for liability. You see why this is a big liability problem for the North Andover PD? And so the judge said that he would defer that part of the ruling until and if and when Justin is on the stand, if he's ever called. Hold please for 1 second. Oh, please. Just give me 1 second. I gotta do one thing. I'll be right back to finish this wrap up. Well, let's just finish it right now. They did talk about a bench trial, and Bradl said, Judge, I think I may be heading towards a bench trial. And so I think that's a really good decision. And then we started talking about the bail conditions. Kelsey wanted to be able to move out of her parents' house and get her own apartment. She already has a lease in place. She already has an address in place. There was a lot of talk about that. Dr. Zeisel was there in case the judge wanted to hear from them. The judge knew Dr. Zeisel. He's a very common witness in the Commonwealth, in all counties. And then they started talking about the order that Judge McCarthy Neyman made that Kelsey have no contact with her baby. And that part of the order was vacated by Judge Karp. Kelsey cried. We all cried. We all cried. So now Kelsey can go fight that out in family court. That part of the Superior Court order was vacated. And then the judge said in the end, yes, she can move into her own apartment. She already has a lease. She wants to nest so that she can tell the family court that she has a place for the baby. What a great day. What a great day for Kelsey. The only condition she will have on that, he also has a lot of questions about the SCRAM device. He has intellectual curiosity. Intellectual curiosity. He went into the court doc and he said, why can't I see this in here? Why can't I see that in there? The probation department will do random visits to her new home, which she will be able to live at on her own. She's not allowed to have any alcohol in the home, and she is not allowed to have any weapons in the home. A lot of intellectual curiosity on the part of this judge. Bradl, it represents Kelsey on the restraining order, which is going to be heard on April 14th in the family court. And there's a Miss Hess representing on the custody, which is there's going to be a hearing on April 2nd. She's in compliance with all of her testing, so that wasn't an issue. No weapons, no alcohol, random visits. Kelsey gets to fight to see her baby, and Kelsey gets to live by herself. Isn't that a great day? I don't know why NBC 10 is still up. It is 1:11. Everybody make a wish. Make a wish, because it's been a great day. I don't know if anybody got any. He did not get, I don't think he got rid of the SCRAM. He didn't get rid of the SCRAM, did he? Hold on. She's passed all of her SCRAM testing. And so she's doubly, okay, that also has a GPS on it, as does the ankle monitors. So she's doubly being tracked. Shout out to the Silver Fox, says Bonita. Tim Bradl, you rock. Well, the house arrest conditions had been already at the last hearing modified so that she only needed to give 2 hours notice, I think. Wait, no SCRAM? Did he take the SCRAM off? Hold on. I can't verify that because my notes don't say it, and I think I would have written that down. The order was vacated as to the stay away from the baby and the living alone, and they can randomly visit. I don't think that he took the SCRAM off. I think he just was curious about how it worked. She's not allowed to have alcohol. He didn't really address it, but he didn't take it away. There's still SCRAM, but who cares? It's a huge win. Huge win for now. And he said, well, there is a change in circumstances because time has passed. Time has passed. That's enough. That's all I need to modify this order. And Gubitosi, do you agree that I can modify this? Because Gubitosi had argued that it should go back to McCarthy Neyman, and Gubitosi did agree. And he I don't think he did. Yeah, she still has to keep the SCRAM, but the way Judge Karp is leaning, I feel like if she comes back again after she's living on her own for a while, and she wants to modify the order, then I think that this judge will allow it. And when he said I'll allow it, that's the first time I was ever happy to hear a judge say I'll allow it, because we used to get that from Judge Cannoni all the time, and it was not in a good way. The I'll allow it was not in a good way. Remember? Thoughts, questions, comments, concerns. How long can Bradl wait to decide to go for a bench trial? It can be right at the last minute. It would have to be before jury selection. Does it have to be before they start jury selection, or can he wait? Yeah, they wouldn't want to waste the jurors' time, or at panels, impaneling time, calling in, the court time. They wouldn't want to do that. It would be before they start calling the jurors in. Great question. And I think, based on the judge's ruling today, I think that might be the way that he's leaning. And I will tell you, that will work much better for my schedule. It would work much better for my schedule to start the trial on the 23rd of March. And so we will see. We will see. She's not allowed to have alcohol in her house or weapons in her house. Correct. Right. If it's not broken, don't fix it. That's what he said, right? It's walking on sunshine today. Do you guys want to see the text messages between Justin's mom and the North Andover PD, or have you already seen those and are we tired? It's already been a long morning. Wow. Wow. Absolutely. Absolutely. You want to see them? Okay. All right. If you haven't seen them, they're all over the twit twat, as some people call it. And you guys sent them to me. So let me see where I put them so I can pull them up. And if they do go with the bench trial, none of this stuff is going to matter. None of the jury questions. You know, it's the less time that they need to spend with the judge. Oh, please. It's a good day to have a good day, cupcakes. I want everyone to have a good day today because it's already starting off as a good day. Oh, Lindsay, thank you for a very generous 100 by Venmo. Says, thanks for your coverage of everything, especially Kelsey. You're amazing. Deborah, thank you for your Venmo. Says, great day for Kelsey and cupcakes. Karen, thank you for the Cash App again. All right. Let me see something here. Yeah, there's also an email floating around from this lieutenant. Well, let's do it in this order. The lieutenant, this Kellie, Kellie of the Stow Police Department. But we would need to look at the text messages first. Thank you, Jessica. She says, thanks for covering Kelsey and Karen Reed. So Jess Machado, I think, posted these text messages that you guys are telling me that she obtained from a FOIA request. All right, hold please. Hold please. Talk amongst yourselves for a second. Okay. What a great day. What a great day for Kelsey. Okay, so I think these were broken by Jessica Machado. All right, 1 second. Well, we pull this up. Okay. This message is on Friday, July 4th, the day after Justin broke into Kelsey's house. Kelsey's in the hospital fighting for her life. Jessica went over it last night. Yes, okay. Some people haven't heard it yet. A lot of people here haven't heard it yet, so we're gonna go over it again. Morning, Kellie. It's Lisa, Aylaian, Justin's mom. I hope you get to enjoy the 4th of July with your family. I just wanted to give you an update, meaning they already were on notice of this. After interviewing several lawyers, we finally found one last night that we really like. He told us that charges are set. It should be on the news today. Kelsey's being charged with armed assault to murder and 2 counts of assault with a deadly weapon. It is a horrifically sad and overwhelming situation. But, hang on a second. But this is giving us a tiny bit of peace knowing Justin and sweet baby redacted are and will be safe. Thank you again for your knowledge and support. It has meant more than I can express. And then this Kelly says back to her, I'm glad you guys feel safe. Always reach out if you guys need anything. Wishing you a happy 4th with your family. So they're tight with a local cop in Stow. Seems that way. And then on July 28th, the next message from Justin's mom is sending this Kelly, Officer Kelly, somebody's contact information with the initials DS, not sure who. And then she says on July 31st at 10:14 p.m., hi, Kelly. This is, again, Lisa, Justin's mom. Hi, Kelly. I'm sorry to be texting you so late. We are just going over plans for tomorrow. And Doug, Ashley, and Courtney are going with Justin to court tomorrow. My son, Brendan, is stuck in Chicago, not able to get home due to flight issues, but I'm going to be here at the house alone with the baby while they are all at court. And I am wondering if you could just ask for the police to do an extra drive-by tomorrow, to do extra drive-bys tomorrow morning and throughout the day. We are assuming that Kelsey's whole family is going to be either at the courthouse or with her, but just in case, I'd rather be extra cautious. Thank you. I hate this. I don't know. I would bet dollars to donuts, whatever the hell that means, that Justin's mom has been caring for the baby probably 90% of the time. Friday, August 1st, Officer Kelly says, will do. Lisa says, thank you. And then September 4th at 6:54 p.m., Lisa says, hi, Kelly, it's Lisa, Aylaian, Justin's mom. I'm sorry to be reaching out, but I just want to touch base. I just wanted to touch base as tomorrow our lawyer is having Kelsey served with the complaint for custody and support at her parents' house where she is residing. September 4th, this is, due to her getting bail. I'm going to point something out to you. She had not been released to the custody of her parents by September 4th. That was misreported in the news, remember? Because we watched the hearing. It took the judge an extra something like 5 days or 7 days to be released. She was not released, in fact, until I think the 8th, and then she went back to jail on the 11th. So they wanted to have Kelsey served with the custody and support at her parents' house on the 5th. She was not yet out of jail. So they got the wrong information. And September 23rd is the hearing for the extension of the emergency restraining and custody order. We just thought you all should know, especially since her dad has been causing quite the scene in North Andover. Thank you. Is it gaslighting? Or was Kelsey's dad really causing quite a scene in North Andover? No more specifics on that, but I have my own opinions. And Officer Kelly says, thank you for the update. Thanks for the update. We keep sliding by your residence as we know she was given bail. If any doubt, call 911. Lisa says, thank you. We really appreciate you and everyone watching out for us. We're very nervous for Justin and the baby. And I always have my phone on so I can call 911 immediately if need be. We have cameras up and doorbell ones go in on Saturday. Thank you for everything. Officer Kelly says, always, you know where I am if you need me. And at this point, Kelsey was out. Lisa responds, I truly appreciate you more than you know. Saturday, November 8th, Lisa says to Kelly, Officer Kelly, hi there. Was that you that just drove by in the police car? Stop in as if it is, with like a smiley heart eyes emoji. Kelly says, not today. I am off. Lisa says, someone drove by in the police car real slow and was kind of looking in, but I couldn't see who it was. So I thought maybe it was you. Enjoy your day off. Hope you're doing something fun. And then Thursday, November 27th, Lisa Aylaian texts to Officer Kellie, allegedly, "Happy Thanksgiving. I hope that you're having a beautiful day with your family. Know that we are so thankful for you and all you have done for us over these past several months. It has been more than you know." Heart emoji. And then Officer Kellie says, "Have a great day with everyone. Appreciate the text. Happy Thanksgiving." Nurse Jones says, "Yeah, she's nervous because she stole Kelsey's baby." January 12th, 10:11 a.m. Lisa Aylaian says, "Hi, Kellie. Happy New Year." Who still says Happy New Year by the 12th? Remember, did you guys ever see that Curb Your Enthusiasm episode where there was like a moratorium on Happy New Year after a certain date? I love Larry David so much. January 12th. Happy New Year. Just wanted you to know that I was thinking of you, and I hope you had a really nice holiday with your family. Heart emoji. Happy New Year, says Officer Kellie. I'll have to swing on by and catch up. I hope you're well. Glad the holiday is over and we're in a new year. Moving forward, be well. Always here if you need anything. And then Lisa says, "Oh my gosh, we would love for you to swing by and catch up anytime," with a heart emoji. January 16th, Lisa texts, "Morning, Kellie. Hope you're having a good week. I'm reaching out because Monday, Justin is having the baby baptized at St. Isidore's at 4 p.m. It's only us immediate family, the deacon and his wife, our foster child and her family, and our moms. But in the court agreement, Kelsey's stepsister, Maddie, is allowed to be there. She's the only one. We're praying the family will respect this and not show up, cause a scene, SEEN, or anything else, but thought we should reach out to see if maybe you are on. You could be driving by or close by just to make sure all's okay. If you aren't, maybe you could ask another officer to." Thoughts? Kellie says, "The PD is right there. I don't think we need to drive by. They have been abiding by the order. If for some reason they do, tell them it's a private event and call police. Don't engage past that. Remain calm and walk away." Lisa says, "Sounds good. Thank you." Just finally, maybe getting blown off. I mean, does that sound to you like an entitled citizen, like somebody who may be receiving favorable treatment from the Stow Police Department, somebody who's trying to create a situation or put them on notice of a situation, someone who's building a case in family court, someone who maybe is the person who really wants to be the guardian of the baby? There's so many thoughts in my head. So many thoughts in my head, but an email surfaced. So let's take a look at that. And this is an email from this Officer Kellie to the department. Let me pull that up for you. And that's what it purports to be. On some of the copies, it has the header, but this copy happens to have it cut off. But I'm assuming this is real because I'm assuming this also came from a FOIA request. But then again, I can't believe everything I read on the internet, and I've been fooled before. So I'm just going to put it out there that just because this is published on the internet doesn't make it real until it's authenticated. But let's take a look at the email from this Officer Kellie to the department. Somebody also pointed out, a lot of people pointed out, that this Kellie has a huge TikTok following. Apparently, she does some sort of cooking videos or something. I'm not really sure. But this was Monday, June 30th, okay? This is the same evening after Kelsey was shot. And I'm going to have a problem. Kelsey. And this is Lieutenant Kellie with an IE, Barhite, BARHIGT. And Monday, June 30th, same day as the shooting. This is Stow PD at 9:36 p.m. This is going to outrage you. She's CCing a whole bunch of people, not even CCing. It's to all of these people, the dispatcher, all of these people. Subject 28 Maple Caution. Evening, everyone. Listen to this. There was an officer-involved shooting in North Andover this evening where Officer Kelsey Fitzsimmons shot another police officer in her agency after a restraining order was taken out by her boyfriend, Justin Aylaian, in Stow. Kelsey didn't shoot anybody. It was involving a custody battle between Aylaian and Fitzsimmons, and when her agency responded to her home to retrieve the firearms, she shot at the police officer and Justin fled the home with the child. I'm sorry, what? This was about a stay away order and a take away the baby order. They were not going there to retrieve her firearms, because if that was the true purpose of their visit, wouldn't they have secured her firearms immediately upon entering that home? They just took her word for it that they were in the basement. What? And so this is the narrative that was spinning in Stow, and maybe that's what this officer was told. I don't know. But we've seen this before. We've seen this film before. Karen Reed. The narrative spinning immediately about the local news media reporting that fled is the only accurate word. Hi, Team Brittany. The media reporting that a girl had run over her cop boyfriend in the snow. There's ring camera. Sources say there's ring camera footage of the incident. News at 11, and that's the way they left it. She has been med flighted, and status at this time is unknown. MSP detectives have taken over the case. There is real concern that her parents will try and come to the Aylaian house. MSP please make sure there are checks several times per shift until otherwise notified. These checks are to be logged. If a 911 call comes in, this residence has been flagged as a caution. Make sure you respond immediately and safely. The family is traumatized over the incident and are afraid right now for the safety of Justin and the infant. If anyone calls, come in for questions. If anyone comes in for questions or information about this incident, please forward them to me, Kellie. Here's the report number. Please read so you have the information. Be careful out there. Lieutenant Kellie, Stow Police Department. So there's that. Yeah, nothing mentioned about her getting shot. Yeah, the whole thing. It was spun, and it's odd, right? Demonizing her parents too. Yes, of course. Thank you, IAN SWT, for becoming a member. Thank you, Kay Willis, for gifting 5 memberships. You're awesome. Oh, you emailed me some Jesus emojis. Thank you, Coco. I stand with Mel. Yeah, I don't know. I don't know if she has an Amazon wish list. That I don't know. Thank you for your 5. Love you too, Sandy. Happy anniversary to us. And we just covered that one. Thoughts, questions, comments, concerns before we wrap. I just want to thank each and every one of you for coming to spend 4 hours of your day with me. And you're going to be behind on the Corey Richards trial, but that's okay. It was a huge win for Kelsey today. Absolutely huge win. And I'll allow it. The judge allowed it. And it's a great day to have a great day. You guys are the best. Please like the stream on your way out. Oh, thank you, Ian, for gifting 5 memberships. Ian, you say Ian, I say Ian. You're amazing. And lots of new members today, and welcome to all of you. Thank your moderators. Tip your servers. Donate to Kelsey's Fund if you can. It is pinned in the chat. Have your notifications set. Do the things. Share the stream out. You know what to do. We need more eyes on this case because the trial is coming up on the 23rd of March, allegedly. The gaslighting and conspiracy. Yes. I love you guys with all my heart. I'll see you soon. I don't know what else to say. Peace out, cupcakes. Love you. Bye.